Hi everyone, good morning, afternoon. I'm just having a bit of technical issues trying to get Hugo back online. So just give me a second, we're trying to sort this out. I'm looking. Get that. All right. I'm going to send him another. Still waiting for Hugo to join us. In the meantime, hope everyone can hear me loud and clear. Just let me know if you're having any issues. If anyone's missing notes, which I had sent out, just let me know.
Yeah, just let us know if you can't hear us.
Okay, so I see Hugo now. Let's see if I can get him on. Now, panelists. Hi, Hugo. Can you get in now? Yes, there we go. There we got Hugo now.
Can you hear me as well?
Perfect.
Thanks, Danny.
Are you, Hugo?
Hello, Stan.
Everything good?
All good, yeah, thanks.
Okay, so I hope everybody's warm. And just give ourselves another few minutes just to make sure that everybody's on, because they are coming in. So another minute, is that okay?
Okay.
There is saw in the news there's going to be load shedding throughout the afternoon. Hope everyone's got certain plans. There is a recording for anyone who drops out and needs to catch up. So just let me know if you need, and we can sort it from there. Otherwise, hope everyone keeps warm and doesn't have too much darkness.
I think we should introduce one holiday a week and just have one extra day's weekend, and we switch off the power everywhere. And then we save electricity, and we have at least, instead of a 5-day work week, we have a 4-day work week.
Absolutely. And thanks to Cape Town City Council, we are on one level lower than the rest of the country, so we only have load shedding for now. So I'm okay for all of them.
That's good to hear. No, it calms my nerves a bit. I know mine's going off in 50 minutes, but I've got a battery backup, so I'm at least hopefully fine for now. All right, I think it's 5 past. Let's, I think, get starting, and I'm sure the others will join as they can. Okay,
so we're into a very topical topic today about exchange control, the problems associated, etc. We have with us Hugo van Zyl, who's expert in the subject and made it his career. And I look forward to an interesting afternoon. Welcome, everybody. Your certificates will be on their way after the seminar in the next day or so. And thank you for joining us today. And those in Johannesburg, I don't know what the rest of the country's like. It's pretty chilly up here, but I'm sure Hugo will warm us up. And Hugo, the floor is yours. I presume we'll have a break at about midway, just a body break, and then we can just continue after, say, 5 minutes or 10 minutes, your choice. So you dictate the terms and the times. It's up to you.
Yeah, so Stan, it's a 3-hour presentation, is that correct?
You're not going to go right through, so about an hour and a half. That'll be about 2:30.
Yeah.
Okay.
But
great.
I'm quite happy to do on an every hour, so.
That's in your hands. You decide.
Okay.
I'm sure these are accountants. They've got big attention spans. They can go after me. Stamina.
It's the smokers, Stan. It's the smokers.
Yeah, that's the problem.
But if they're at home, they can smoke. So
and in my experience, you can't argue with smokers.
Absolutely. Thank you, Stan. Thanks. So everybody, thank you. My name is Hugo van Zyl. As you heard, I'm a chartered accountant. I specialize in cross-border expat matters, and exchange control being one of them. It is very important to understand at the beginning, and I'll say it at the end again, this is my personal opinions, and it's based on real experiences. I will point out to you where the guide says, the authorized dealer manual or guide says one thing, and the practice at authorized dealer level is totally different. Okay, so some of you may have seen that my comments on this slide has been captured in a MoneyWeb article by Amanda Visser. So just go and Google on MoneyWeb. You will see that the issues we are facing is real, and we have decided to escalate it. So it's me and a few other individuals, 1 or 2 larger companies that can't really go public as I could go as a small practitioner. And most important is the industry that has really faced most of the issues is the people dealing with deceased estates and trying to get people's money out of the country, but we'll deal with them a little bit later. Okay. So why? Okay. So upfront, very important is that I'm dealing with the authorized manual dated 25th of April 2022. And about half an hour ago, when I went to the Reserve Bank page, www.resbank.coza, it was the last published manual, and the last circular was circular 16 of 2022. I'm also going to deal with the 2021 circulars, but note that they have been updated. And on circular 1, we do anticipate to have an updated or revision or total change in the next few weeks. Okay. Then on the right-hand side, SARS, we are looking at the tax law amendments up to 2021 that was promulgated early in 2022 or published in 2022. But most importantly, I have taken into account some changes of the 2022 draft TLAB. As the draft stands at the moment, it's a draft TLAB. I'm not too sure if all those changes will go through, but I will point them out as we go along. That may be a little bit controversial. When we deal with exchange control and tax, it becomes very confusing because we are dealing with the word resident. So the bold resident in the middle. When I, in this seminar, refer to the word resident, assume I'm referring to the exchange control resident. I will try and always say tax resident when I mean the income tax definition of a resident. Okay. So that is the big bugbear that we are facing at the moment, is that there's a definition of resident in the Income Tax Act. There's a definition of resident in the Authorized Dealer Manual. And then there's the word ordinarily resident in the State Duty Act. Okay, so the State Duty Act is very specific. It deals with an ordinarily resident person. So very important. We'll deal with it again later. When someone has ceased to be a tax resident in terms of a double tax treaty, that person remains ordinarily resident in South Africa, and they are subject to South African estate duty on worldwide assets. I'm going to repeat that. Very controversial, but this is fact. When someone has tax immigrated, so he's no longer a resident in terms of the Income Tax Act because a double tax treaty consider him non-resident for income tax purposes. He remains ordinarily resident in South Africa and subject to estate duty in South Africa on a worldwide basis. There are there's 3 treaties dealing with estate duty. It is the USA one, the UK one, and then the Botswana, Lesotho, and Swaziland one. So let's quickly run through them. Very important. When I refer to AA, I'm still having all my drinking habits. I'm referring to authorized assets, regulated assets. AD is an authorized dealer, most of the commercial banks. DTA is a double tax agreement or treaty. Excon is exchange control, or now FinServ. Excon resident is the SARB, the Reserve Bank definition in the AD manual, but do note when I refer to resident in the presentation, it will be that Excon resident. Immigrate now cease to be tax resident in terms of the Income Tax Act. In Circular 6 of 2021, they made it very clear the concept of immigration in terms of Reserve Bank rules and AD manual was phased out. I will just refer to FE, being formal immigration, using the MP336 process, the one that ended 28th of April 2021. And some people may want to call it financial immigration. It is so painful in my ears, I hate to use the word, so let's just use FE or formal immigration. FinServ is then Excon. Income Tax Act, ITA, 1961 as amended until 2021 changes. SARB is Reserve Bank, SARS is Revenue Services, and then a tax resident is a person that is resident in terms of the Income Tax Act. So there is no definition of the word Excon resident, and there's no definition of the word tax resident. But when I use Excon resident, I refer to the definition in the authorized dealer or AD manual. When I refer tax resident, I refer to the resident definition in the Income Tax Act, and I then exclude from resident anyone that is deemed to be solely resident in a tax treaty country. So we all know the income tax definition of the resident. We are now looking at the definition of the AD manual as of 25th of April 2022. A resident means any person, i.e. a natural person or legal person, who has taken up permanent residence, is domiciled or registered in South Africa. For the purpose of the authorized dealer manual, this excludes any approved offshore investment held by the South African resident outside the CMA. So that's very important. For purposes of the authorized dealer manual, this excludes any approved offshore investments held by the South African resident outside CMA. One of the questions we had before the webinar was, what about the people who obtained approval for more than 10 million Rand and then had to treat that as part of their South African assets? Okay, they had to annually report. Interestingly, the annual report has not been switched off, but those assets in excess of 10 million is first of all no longer subject to resident or non-resident status. However, the person who owns the asset, provided he is a resident, remains subject to exchange control. So by implication, if you have become Excon non-resident, you are no longer subject to South African regulations. So we assume at this stage that the reporting obligation, the annual reporting obligation, will be switched off. Why we say assume? There's no provision in the AD manual for the continued annual reporting. And remember, this change only happened on the 21st or 23rd of February, budget date. Okay, so this is a very new change and we have no practical experience at this stage. A resident account means any account of a person that is a resident, domiciled or registered in South Africa, including that of a CMA resident. Now that's extremely important to understand that, okay? So even if you have ceased to be a tax resident and moved to Botswana, Lesotho, or Swaziland, your South African bank account remains a resident account. You cannot, according to this definition, apply to conduct a foreign bank account in South Africa, a CFC, or a non-resident bank account. A resident temporarily abroad means any resident, now it's an exchange control resident, who has departed from South Africa to any country. Can you see, you just have to depart. with no intention of taking up residence or who has not been granted permanent residence in another country. With no intention taking up residence or permanent residence. So someone who has departed from South Africa for Australia, in terms of the double tax treaty, while on the 457 visa, remains tax resident. But strictly speaking, in terms of the resident temporary abroad, he is not a resident temporary abroad because he has intention of taking up residence and converting his 457 to a non-resident status. Equally, your EB2 and EB5 visa applicants to the USA, they have the intention, that's the reason why they're going EB2 and EB5, they want a green card. And a green card is permanent residence in America. Therefore, they may not qualify for the temporary residence abroad benefits. We'll deal with the benefits and pros and cons a little bit later. Okay. And has not been granted permanent residence in another country. And then it excludes those residents who are abroad on holiday or business travel. So if you just travel out for 2-3 weeks, or even a month, you are not a resident temporary abroad. You're a resident on holiday. I, for example, live in the UAE 6 months of the year in Dubai. I am a resident temporary abroad because I have neither tax immigrated, nor have I undergone the ex-con immigration or the formal immigration in the past. I always come back to South Africa. That is my home country. So therefore, I am a resident temporarily abroad. And I'll deal with the benefits. The most important one is that I can take my annual living annuity, my pension, out of South Africa over and above my single discretionary allowance. So I can take out my R1 million without tax clearance, and I can take my living annuity or annual pension or monthly pension out of the country. Yes, don't laugh about it. You can see the grey beard. I have formally retired from the pension fund of a big bank. So a lot of people ask me or say to me, stop using the word exchange control because it's now FinServ. That's correct. The department has changed, yet the publications are still called Exchange Control Circular number 16. Okay, so therefore I think I'm entitled to continue using the old-fashioned term ex-con or ex-con control. Okay, I do admit it's no longer the ex-con department, it is now the FinServ department. So what in terms of the Reserve Bank rules is then a non-resident? Now at this stage we must just quickly put in perspective. An AD manual, the one that I'm quoting, is equivalent to an interpretation note issued by SARS. SARS issues various different interpretation notes, and together they make up the legal counsel or advice SARS has given taxpayers. But the AD manual is one single manual where all the policies and guidance are put together, but it's in itself not an act. It was issued in terms of the Exchange Control Act, but it's not an act in itself. Okay, so very important is that, and I think you'll see that in the MoneyWeb article, I do not blame SARS for the mess we're facing at the moment, because after all, SARS has not changed rules. SARS can't change rules for that matter. National Treasury changed rules. SARS must apply the Income Tax Act. The definitions in the Income Tax Act has not changed. So the tax laws, as referred to in the Tax Administration Act, has not changed. The changes was at Reserve Bank level and their interpretation of the rules. So therefore, I think my heart goes out to the people at SARS facing all the aggression and confusion. I do blame National Treasury, both Reserve Bank and SARS report into National Treasury, and they are the policymakers. They are the, let's call it the translators between the politicians and the people monitoring and controlling South African financial affairs. Okay, back to the definition, enough of politics. A non-resident for exchange control purposes means a person, for example, a natural person or a legal person, whose home, place of residence, domicile or registration is outside the common monetary area. So can you again see that looking at the last bit, the common monetary area is South Africa, Lesotho, Botswana, Swaziland, eThekwini, and Namibia. So someone who has ceased to be a resident and went to the CMA countries, okay, that person can't claim to be non-resident for exchange control. They can be tax non-resident, but they can't be non-resident for exchange control purposes. Very important, it says their home or place of residence must be outside South Africa. Now that's an interesting concept, because nowhere in there, in this definition, does it state that to be non-resident, you need to follow a tax process. However, in the manual, it seems to indicate that you need to follow the tax process and obtain a TEC, tax immigration clearance. So it's a very specific TCS thin letter called the TEC. The non-resident areas means all the other countries other than those in the common monetary area. So again, someone who is in Namibia is not a non-resident for exchange control purposes. Non-resident RAND account means RAND from a non-resident account that may be deemed in certain circumstances permissible elsewhere in the dealer manual as an acceptable payment mechanism in lieu of foreign currency. It should be noted that non-resident RAND cannot in any manner be defined as a foreign currency. Very, very important, okay? That's purely RAND held in a non-resident account. So when you have a foreigner that comes into South Africa, he's never lived here, and he buys a property in South Africa, he can bring in dollars and he can convert some of that dollars to RAND so that the banker can issue the guarantee to the lawyer who's doing the property transfer, because they want to make sure that there's adequate rands and the up and down of the currency fluctuations will not impact on the guarantee. A non-resident RAND account means a RAND account of a non-resident, okay, conducted in the books of an authorized dealer. Okay. So non-resident RAND can be with any bank. A non-resident account specifically is an account held with the South African authorized dealer. Income transfers is defined as transfers in respect of dividends, profits, and current income accruing to a non-resident of the CMA and private individuals who cease to be a resident for tax purposes in South Africa. Can you see? There's a big and between CMA and private individuals. They didn't go ahead and say transfers in respect of dividends to non-residents of the CMA, including private individuals. So therefore, it seems that not only is foreign assets, non-resident assets, and resident assets something that remains as a problem for exchange control, it seems that the authorized dealers must treat or consider or classify a true non-resident, someone who's not born in South Africa and never lived here, differently to a private individual who ceased to be a resident for tax purposes in South Africa. Okay, so there's the conditions laid down, and we'll get to them later. So my question is, the word "and" between non-resident of the CMA and private individuals, okay, should perhaps have been including, because that is what the minister promised us in February 2020 when he announced the abolishment of FE, or formal immigration. By using the word "and," it says a private individual has ceased to be a resident for tax purposes. So it's quite interesting if we go back there, okay? It says, and a private individual who ceased to be a resident for tax purposes in South Africa. So therefore, income transfers to a person outside of South Africa but living in the CMA that is tax immigrated is still an income transfer to a non-resident. And we foresee very little problems in that. But can you see that for income, a person who ceased to be tax resident, irrespective of where he is living, is quite okay. But the minute we go back to that definition of a non-resident, you must be outside the CMA to be a non-resident. Okay. So it seems that the manual contradicts itself. But this is only in respect of income. But for most of you who will know, transferring of income, rentals, dividends, salaries from South Africa to Namibia, Swaziland, normally not a problem, okay? So therefore, resident or non-resident for purpose of the AD manual. I'm just questioning, where in the AD manual does one find certainty that a person ceased to be a tax resident, apologies for the spelling error, is now deemed to be an ex-con non-resident. There is no such a clause. And where they refer to the two types of ex-con non-residents, they go ahead and they use the word "and" as if to distinguish between them, to say they're two different types of classification. If you go back to the income transfers to someone who has ceased to be a non-resident seems to be not restricted. How does the authorized dealer know that that person is tax immigrated? We have asked repeatedly to SARS and FinServ for comments on how do they communicate with each other. There seems to be no formal communication. And more scaringly, there is absolutely no obligation on an authorized dealer to determine tax residency. I'll explain later where the abuse are coming in, and it's actually happening at the moment. The other problem we have is that someone in the old formal or financial immigration era did not require to obtain a TEC, tax immigration clearance. Now he has no evidence that he has tax immigrated from South Africa, okay? Because remember, the words are very clear, you cease to be a resident for tax purposes. So it's the taxman who must certify. So sadly, for all you who've been selling formal immigration and made clients pay for that, it's useless. The income transfer does not even refer to someone who has previously formally or financially immigrated. You must have tax immigrated on the SARS system. Where does the problem come in? We have immigrants who left South Africa before the tax immigration clearance was introduced. So those who left between, well, in the 90s up to about 2012. In 2012, they started with the tax immigration clearance, but it was not an absolute requirement. By 2015, 2016, it became an absolute requirement, but there was this one exclusion. If you had no active bank account and your only assets were retirement annuities or retirement funds and SA life insurance, you didn't need to get a tax immigration clearance. You didn't need to go past SARS. So those persons or those applicants never notified SARS whether their tax number was dormant or not, inactive or not inactive. So we do have a lot of persons or individuals having completed formal immigration, but have not gone past SARS. Okay, they are not able to comply with this previous requirement. They cannot show to an authorized dealer that they have ceased residency for tax purposes in South Africa. And now authorized dealers are not happy with just a declaration. They want a new form TEC, tax immigration clearance, which means people who were inactive or, for example, never had a tax number on the South African tax system are now obliged to re-register, reactivate their e-file profile so that they can get the new form of TEC. Now we go into the Tax Act. The double tax agreement refers to habitual resident. Okay, so when you are no longer ordinarily resident in South Africa, okay, then you're most probably ex-con non-resident, because remember, you now have a permanent home, or you left with the intention of not returning to South Africa. Nowhere in the manual does it state that you need to get a tax immigration clearance, but we see that the way authorized dealers are interpreting it is that you need a TEC, not just a TCS good standing. And this causes huge problems. If you are no longer ordinarily resident for tax purposes, there's no South African estate duty unless you have South African sightless assets. So what happens is someone who is no longer ordinarily resident and has no title deed properties in South Africa, when they pass away, there's no obligation to register a deceased estate in South Africa. To the extent that there is assets in South Africa, but it's not immovable property, the Estate Administration Act in Section 25 says that you can register the foreign executor and his appointment will be accepted in South Africa, provided he gives an undertaking to run the estate duty calculation past SARS and get the necessary approval. If you then have an estate registered with the master, there is some catch-all for people with domestic policies. But where that person has left South Africa, has absolutely no bank account in South Africa, no assets in South Africa, there's no obligation to register a deceased estate in South Africa. However, in terms of our estate duty, that domestic policy that stayed in place, whether paid from abroad or paid up or paid in advance, remains a deemed asset in his estate. Yes, the first 3.5 million is exempt, but remember, Section 11 of the Estate Duty Act actually provides that the beneficiary must pay that estate duty. The executor is allowed to collect that from the domestic policy's beneficiary. If there's no executor, who's going to do that? So what I'm trying to point out is that because National Treasury has not considered this consequence of the change in ex-con rules, there is a severe problem in estate duty not being collected. They did go so far to say that if that domestic policy then pays out, the fund or the insurance company can pay up to 10 million rand to a foreign national or an immigrant, provided that person is dormant on the SARS tax system or has no tax number. Again, the authorized dealers sit with the problem, how do they prove that? How do you prove to them that you're inactive on the SARS system? So again, we have a policy statement saying below 10 million, you don't need to go past jail, you can go directly and transfer the money out. But the authorized dealers have no way to certify that. The new rule states that if the value exceeds 10 million, then you can do a manual letter to SARS. Therefore, you do not need to register for tax and e-file. You can purely request an e-file, an email request is sent to SARS to say, issue me a letter of good standing. So what I'm suggesting, even if it's below 10 million, you send that letter to SARS, and then let SARS come back and say it's below 10 million, you don't need to go past us, and you give that reply to the banks. The other problem we see is that people that have left South Africa to the USA have changed their South African trust deed to make it a vested trust, or to give the founder what we call certain grantor rules. I'm not going to go into the American system, but in terms of the American system, they do not tax the funder necessarily. The first person in line to be taxed is always the grantor. So if you made, and the grantor must have rights to grant or not grant. So by changing the South African trust to say that the South African immigrant, the person who's left, is now the grantor, that grantor, the immigrant, the person now living in America with the green card, is taxed on an annual basis. That saves the beneficiaries from the throwback tax. So it was an attractive option from an American perspective. But in terms of estate duty section 33D, that assets in the trust now become subject to estate duty in South Africa. Whether there's an executor appointed in South Africa or not, when I get to review these documents, and then so happen to know that there was a trust deed amendment sometime, I always have to argue with the executor and say, you have excluded assets from the estate duty calculation that is deemed to be an estate dutiable asset in terms of section 33D. So again, National Treasury has overlooked a good opportunity to tax trust assets. However, contradict what I've now said about no longer ordinary resident, okay, with a tax treaty resident. Reading the manual, that person is ex-con resident, looking at their definition, okay, because he has not taken up permanent residence. So for example, I live in the UAE. I do not have a permanent home there. I don't even have an habitual home there. I go for short periods of 2 to 3 months, and I do a short let. You cannot call that my habitual home. You can't call it my permanent home. So in terms of the ex-con definition of a non-resident, I fail that completely. I am a resident because I have not left South Africa with the intention of not coming back. However, when it comes to income transfers, should I tax immigrant purely because of the treaty? So the treaty says the minute I give up my South African home and I only have a UAE or Dubai home, so let's turn it around. I go and rent, and they call it an Ajari. I rent and register my apartment as a permanent apartment in Dubai. I then give up my South African residence, and when I come and visit South Africa for the other 6 months of the year, I do short lets or Airbnb. Then the treaty deems me to be exclusively tax resident of the UAE. But I fail the ex-con resident because in the UAE, there's nothing like a permanent residency permit. Those permits are 2 to 3 years. Even their new green visa or their golden visa are only for 10-year periods. Unless you were born in the United Arab Emirates, you will not be granted a passport, and they don't have the concept of a permanent resident. So it's quite interesting that most people there consider themselves permanent residents because the renewal is near automatic, as long as you continue with your employment in the UAE, or provide that you do not fail their medical test, they're very strict on medical tests, you can continue to be a resident. Unlike any other country, they have no test about English ability or age. There's no restriction on age. In the UAE, if you register a company and you are the director and the only employee of the company, or your wife is the only employee, spouse, then you can have a residency permit, but it's unfortunately not a permanent residence permit. For treaty purposes, okay, I may then have an habitual home in the UAE. So the treaty goes on to say, if I have a home in the UAE, which is my permanent home, so I've signed the Ajari lease, and I have a home in South Africa, let's say it's my holiday home, then I have a home permanently available to me. Remember, permanently available does not mean you have to own it. It must just be available to you, can be owned by a trust. The next test is then your center of vital interest. The center of vital interest is then very confusing because I may be earning my income from my Dubai company and nothing in South Africa, but my family and close ties on South Africa. So my center of vital interest remains undecided. Therefore, I have to go to test 3 in the tiebreaker. Tiebreaker test 3 says that you will be deemed to be solely resident in the country where your habitual home is. And we've seen in the recent Oppenheimer case, an habitual home has never been defined in South African law, but that's the home where you go back to most often. The words that was not used in the Oppenheimer case, but which I have been using in my opinions and my guidance to clients, is an habitual home can never be a purpose home. So the Oppenheimers effectively claimed that the UK property has a purpose. It is to school their children in the UK system. Another example, far easier. If you are working on an oil rig or on a compound in a mine in the DRC and you're on duty 6 weeks, you're living in the compound 6 weeks, and you come back to South Africa, habitual home, you don't count the days because that 6 weeks is a purpose home. It's not your habitual home. You habitually return to your South African home. That is where your habitual residence is. Now, for example, there are many South Africans who have no habitual home in South Africa. So therefore, the treaty says, because your South African home is rented out, or it could, for example, be in my case, a little holiday home in Cape Town. That's not an habitual home, it's a purpose home. You go there for holidays. You don't return there at the end of all your journeys. You don't return there regularly, every month or so. You only go there once a year for holidays. That's a purpose home. Therefore, the habitual home is clearly my Dubai home. That being the case, I am tax non-resident, deemed to be solely resident in the UAE in terms of the treaty. SARS has the right to charge me an exit tax. Now you can see why I'm not doing it. One doesn't want to pay that exit tax unnecessarily if you're coming back. But for exchange control purposes, you are not ex-con non-resident. But is it such a disaster? No. Because should I be prepared to pay that exit tax, and SARS then deems me tax non-resident in terms of the treaty, the beauty is that all my dividend income, rental income, and interest income in South Africa can freely flow from South Africa to the UAE. So it's very important that when it comes to capital transfers, it's important to be ex-con non-resident. But when it comes to income tax transfers, all you need to prove is that you're tax non-resident in South Africa. Okay, so if your clients have tax immigrated, you have a TEC, tax immigration clearance, you can ask their bankers to transfer dividends, profits, and current income, wide definition. Elsewhere it says net income, okay? So after paying your South African taxes, can be remitted to the individual in a foreign country, provided he has ceased to be a South African tax resident. Now again, let's think of someone living in the UAE. I may have a tax immigration clearance dated 2016, 2017, but I've in the meantime come back. There's no obligation on the authorized dealer to check that I remain tax non-resident. Because when I transfer the monies for my clients, so remember, I am still exchange control and tax resident in South Africa, but I have a lot of clients who are no longer. When I ask then on behalf of my clients to transfer their South African dividends out of South Africa based on that income transfer rule, because we have submitted the TEC in the past, the authorized dealer at the moment only asks for a TCS good standing. I'm saying this letter that SARS is so difficult to issue, the one that says you have tax immigrated on a specific date, should become a standard issue to everyone. But there should be a central register where the banks can check that you have not returned to South Africa. Because remember, in the old FE era, formal immigration era, you had an obligation to notify your banks that you have returned for ex-con purposes. Interesting, there's no obligation on you to notify your banks of your change in residency status. The only obligation you have, and it's a common reporting standard, CRS, is that you have to notify your bank of all the countries where you pay tax. So one day when I came back to, for example, South Africa, but I lived in England before, I may still have a property in England. I'm now a tax resident in South Africa, but my CRS update will only state that maybe my FICA address has changed to South Africa, but I will still have to link or list my UK tax number. And remember, on estate duty, when you are DTA or treaty non-resident, you pay South African estate duty on worldwide assets. But who is tracking that? Not SARS, as treaty non-resident reports only report South African source income. So remember, when you're tax filing your tax return, now living in a tax treaty country, albeit for 2 or 3 years only, you're reporting to SARS only your South African assets. Because you've paid exit tax on your foreign assets, you no longer have to report South Africa, non-South African assets. Furthermore, very seldom does SARS ask a balance sheet for someone who earns only dividends. So someone can have tax immigrated, have a 10, 20 million rand share portfolio in South Africa that may escape estate duty because that asset is not listed on the SARS profile. Assume that exact same asset base is now listed in London and a little bit in New York. Remember, their joint accounts are possible. So therefore, that money need not wait for an executor to be appointed, be it in South Africa or in a probate officer in the UK. The surviving spouse who holds the joint account can immediately transfer that assets into her or his name. So therefore, again, because those assets are foreign assets, SARS are not even aware of it anymore because you've only paid the exit tax. Or when you left South Africa, that assets did not even exist. So unfortunately, although the switching off of formal immigration is welcomed, I do not think National Treasury has thought this through. So we have theoretical tax laws that is extremely difficult to monitor. Because remember, most CRS reporting at this moment is about trusts and trust income and income streams. It doesn't always list the balance sheet assets. Okay. So now we have to look at what the Reserve Bank says about private individuals resident in South Africa. Okay, so foreign investments by private individuals, natural persons, resident in South Africa is treated as follows. Authorized dealers are advised that a valid green barcoded South African ID document or smart ID card is the only acceptable document proving residency in South Africa. Okay. Although this clause appears below a heading that reads private individuals resident in South Africa. So this ID document is all that you need. You don't need a tax number in South Africa to prove to the Reserve Bank that you're resident. But what's happening now, and most of you have probably seen that, when you try and open a foreign bank account or non-resident bank account, and the foreign passport, so he's lost his South African passport was withdrawn because he didn't get permission for dual nationality. But the American passport still reads born in Johannesburg. Immediately, the authorized dealer deems that person to be a resident. When I challenge them, they quote this and I say, since when is an American passport a green barcoded ID or smart ID document? The authorized manual does not state that anyone born in South Africa is deemed to be a private resident in South Africa, a private individual resident in South Africa, but authorized dealers are applying that rule, much to the frustration of many, many persons who has formally immigrated. So someone who's formally immigrated could have done so on an indefinite leave to remain in the UK or a green card. So that person is still traveling on a South African ID and a South African passport. That person is a Home Affairs resident, but they are not proving residency in South Africa with that ID card. That ID card purely proves that they are South African for Home Affairs purposes. But this very confusing provision is then used by authorized dealers and applied to any private individual non-resident in South Africa. So although subheading bracket B, capital B says, this rule only applies to private individuals residents in South Africa, authorized dealers apply this to anyone wherever they live in South Africa. So I recently had the situation where a child, 17, it's just over 16, he was about 17 years old, born in America. His parents got him a South African ID because it's his birthright. He has never put foot in South Africa. He's never even visited South Africa. He has now inherited from a South African grandparent and must open a bank account to receive his inheritance. Why? Because his inheritance is more than 10 million, we could go for a permission to transfer the cash out, a manual clearance. But he's inheriting 1/6 of a South African property, so there's rental income. We can't transfer that 1/6 out of South Africa. We now want that title deed to be cleared as a or 1/6 of it as a non-resident asset. At this stage, virtually impossible, because he has a green barcoded ID. He's never converted it because he's not been in South Africa to smart card. And he has an American passport that says born in America. However, the authorized dealer treats him as documentary proof was received that he's resident in South Africa. An absolute joke at this stage. And exchange control, an AD, has an obligation to test tax residency. The answer is no. There's zero obligation, absolute zero obligation. There are certain places where transfers are restricted, subject to the submission of a tax immigration clearance certificate. But that could be an outdated one. You could have been back. In certain cases, as for income, as we've showed before, as long as I can show that you have a tax immigration clearance, although it's 6-7 years old, and a tax good standing certificate, which does not indicate tax residency, your income can flow out of South Africa. Legally, it appears, despite you living happily in Camps Bay and Cape Town. So let me quote. Where a resident, as a definition A1, okay, but by default, ADs treat any born South African person or foreign national with a South African ID as ex-con resident. Yes, and it goes as far as non-citizens with permanent residency. So a non-citizen, for those of you who don't know, when they have a PR, permanent residency, issued to them, they have a green barcoded ID, and it shows the word non-citizen on it. And they, up to now, as far as I know, could not have converted to smart cards. The smart ID cards are only available to citizens. But the minute they present that to the bank, they are deemed to be an exchange control resident So at this stage, formal immigrants, being non-residents, not in possession of a tax immigration clearance, lost their ex-con status. Okay, so it's very important. They have lost their ex-con status. They will have to apply for a new TCS PIN, tax immigration clearance. Okay, so I'm asking the question there, but I'm answering you now. This is our experience. The formal immigration era's TEC was a joke compared to the current process. So we have seen one or two big banks, more the international big banks in South Africa, asking for an updated tax immigration clearance. And now we see the current process declines the tax immigration clearance. Yet the client is very unhappy, the taxpayer is very unhappy because he has a tax immigration clearance certificate dated 2019. But if you look at that tax immigration clearance, although it was called a tax immigration clearance, it was purely a clearance to state that you have complied and paid the exit taxes. It did not confirm that you tax immigrated, because remember, unless you cashed out retirement annuities, there was no obligation to obtain a TRC or tax residency certificate from another country. So yes, I take a lot of flack in public social media and on LinkedIn, but to my mind, a formal immigration era tax immigration clearance is worthless. And we are finding huge problems with that. So where's the abuse that we are seeing? We'll see later that last year there was confusion. We had Exchange Control Circular 6 and then Circular 8, and Circular 8 replaced certain parts of 6. And in terms of Circular 8, the single discretionary allowance was removed from non-residents. If you are therefore tax non-resident, again, the AD manual doesn't refer to ex-con non-resident, it refers to a tax non-resident person can only apply for their single discretionary allowance in the calendar year that they tax immigrate. Yet if we look at what the authorized dealer instructs, the dealer manual instructs the authorized dealer, it reads, the resident individual must produce a valid green barcoded South African ID document or smart ID for identification purposes. Earlier it was to show residency, now it's for identification purposes. And it's a mandatory reporting item. We do see most authorized dealers, in addition to the ID, also asks for a tax number to send the 1 million out. There's no obligation or restriction in the authorized dealer manual that you have to have a tax number, because you could be 18 and advanced and still have no tax number, and you're entitled to send R1 million out. So the identified abuses. Once you have ceased to be South African tax resident, and you have submitted that proof with an authorized dealer, say ABC Bank, in this year, they restrict you. But next year, you open a new bank account, South African Rand account, with XYZ Bank, but you do not provide them with your TEC PIN, because in the second tax year, SARS doesn't issue you with a new TEC PIN. They just issue you with the TCS good standing PIN. So the minute you give that TCS good standing PIN and your ID number, you can again remit R1 million out of the country in contravention of the AD manual. Yet there's no obligation on the authorized dealer, XYZ, to go and double check if you have or have not tax immigrated or maybe have returned to South Africa to become a tax resident. Furthermore, if you're inactive on the SARS system, remember I said you can remit R10 million of inheritance via the executor and his bank account. So the executor bank account, the deceased estate's bank account, can send you your 10 million or less out of South Africa, provided there's an ID number, or if there's no ID number, evidence that you never lived in South Africa. But when you have a South African ID number, you must be inactive on the SARS system. So SARS letters contain old tax numbers, okay? Now, if you then use that old tax number, it's an inactive tax number, the authorized dealers may not allow you to take the money out. But if you sign a declaration, you go to SARS, you get that letter, then you can take 10 million rand out. Again, if you go from ABC to XYZ, you can take more than 10 million rand out. We hope, and I do believe it is indeed done, that the South African Reserve Bank's FinServe department will monitor this on an ID number basis. But do note, where the person has no ID number, so they've never lived in South Africa, born outside South Africa, and they're inactive on the system, the remittance may be on different passport numbers, because people can have multiple passports. Then there's no ways for the Reserve Bank FinServe department to monitor that inheritances in excess of 10 million did not go past SARS. So I'm asking, is it not time that there's a central database of tax non-residents? At the moment, it's not. There's no verification possible to check the ex-con status or the SARS status. This obviously brings huge POPI Act and other confidentiality matters to issue. But if they want to then abdicate, if the Reserve Bank wants to abdicate, not they want to, they have abdicated to SARS, the tax non-resident status as an exchange control status, then there must be a way for authorized dealers to check this. You can't send the letter to SARS, it's going to take you 21 days, no reply, and then you apply again. The authorized dealer can't phone SARS because they do not hold the e-file profile on your name. And in most cases, you're inactive on the system, so no one should hold your profile. So therefore, verification at this stage is virtually impossible. And you, as a taxpayer, if you're the individual inheriting, you can set up a telecom with SARS and they will confirm there's no active tax number. But they're not going to issue a letter to say there's no active tax number. So again, how do you provide the evidence to the authorized dealers? So in a way, I feel for the authorized dealers because they have been placed under an obligation to verify your status without being given the tools. National Treasury has brought in the below 10 million rule without thinking how this will be verified. Finally, on the single discretionary allowance of people that have tax immigrated, okay, we do hope the authorized dealers or the Reserve Bank, FinServe, will be monitoring this on an ID number. because for most people, they don't even ask the tax number. We do know most authorized dealers ask a tax number, but you can just state that I've never had a tax number, and they will let your money flow out of South Africa. So before we take the first smoke break, it's time to align, I argue, all the various tax acts and the authorized dealer manual. Tax treaty non-residents can change their tax status annually to come in and out of South Africa. Because remember, the tiebreaker test is a factual test. Let's take my example again. If I give up my Cape Town primary residence and I rent in the UAE, I am immediately deemed to be solely tax resident in the UAE. But the minute I then buy a second property or obtain a second property in South Africa, I now have a permanent abode available to me in both UAE and South Africa. Then we go to the second part. I may be living in the UAE with my family, but I may be working for my South African company that my family trust owns. Therefore, center of vital interest is split. My closer ties financially, South Africa, my closer ties family, UAE. I then have to go to the tiebreaker test, and now we look at what is my habitual home. If it was a holiday home, probably not an habitual home because it's a purpose home. But if I'm flying back to South Africa every 6 weeks to come and spend a week in South Africa seeing my clients or reporting to my employer in South Africa, as we have seen in the Oppenheimer case, that makes South Africa your habitual home. So therefore, it could be that you change on an annual or biannual basis because of a tax treaty. There's no ways for the Reserve Bank to monitor. In the old formal immigration days, you were only allowed to operate blocked accounts with one authorized dealer. So that authorized dealer understood your entire profile. Now you're allowed to use multiple banks, and there's no central register for ADs to compare. So we'll later deal with the 100,000 once-off dispensation. But I have seen in this short period, it was announced on the 23rd of February, I have seen an abuse of the system where people are sending out more than 100,000 because they have in each bank account of two different banks, less than 100,000. Where the rule actually says if your total cash was below 100,000, but we'll deal with that next session. Ex-con advisors agree with me that the post-formal immigration compliance has become more complex and uncertain because the Reserve Bank has abdicated without National Treasury understanding the consequences and the mismatch and definitions. So I argue that there is discord between SARB and SARS, but can we blame any one of them? We must probably point fingers at the National Treasury, who was supposed to give policy guidelines and amend the tax acts if they wanted to align the tax rules to the Reserve Bank, or if the SARS decision on non-resident is now the final decision, then they should remove the definition in the Exchange Control Manual that conflicts with the South African income tax definitions. So for now, I'm going to just stop the sharing, and we will have a 5-minute, no, not even 5 minutes. So what's the time now? It's 5 minutes past. Let's reconvene at about 8 minutes to 10 minutes past 2 o'clock. Right, everybody. I think it's now about 9 minutes past. I think everybody should have joined back, had the smoke, and hopefully a warm cup of tea or coffee in the hand. So we do know, and we'll see it later when we look at the different circulars, but from the AD manual, the summary of everything that is in that circulars is as follows. In subsection J, it says private individuals who cease to be residents for tax purposes. So the heading refers to tax purposes. It does not refer to the word exchange control. Okay. So the concept of immigration, as recognized by the Financial Surveillance Department, okay, has been phased out with effect 1 March. It wasn't a phase out, it could have happened. Okay, we were warned, but it happened on that day. So quite interesting. If you look at what the lexicon or understanding of the word immigration is, that is changing from leaving a resident and becoming a resident somewhere else. It appears that you, from that sentence, that if you were resident for exchange control purposes, okay, the recognition to become non-resident in terms of Reserve Bank fails. Okay, so sadly, that is how it reads. I don't think that was the intention, but that's how it reads. However, they say the distinction between South African resident assets and non-resident assets remains extant. So the rules remains the same. Okay, a non-resident, less controls, a resident, lots of controls. Okay, so South African resident in this sentence means an exchange control resident. Okay, the assets and the rules remained in place, subject to the small changes that we'll discuss later. Then they say authorized dealers may allow transfer of assets abroad, provided a private individual has ceased to be tax resident for purposes in South Africa, has obtained a TCS in respect of immigration from SARS, and is tax compliant upon verification of the TCS. Okay, so what's hidden in this little sentence is that TCS immigration could be dated 5 years back. So you could have done the TCS, tax immigration, on the old system. But if you want to remit the money out of South Africa, and remember it deals with assets, okay, we need a TCS good standing. Okay. Earlier we dealt with income transfer. So assets, in your mind, see capital. The definition of capital between Reserve Bank and capital for capital gains tax, not exactly the same between SARS and Reserve Bank, but assets, to transfer assets abroad. Okay, so therefore, we see that even if it's an old immigration letter on the old system, when SARS did not confirm that you tax non-resident, the authorized dealers accept that. They failed to understand that that letter was a compliance letter, didn't say that you immigrated from SARS. Okay. However, it's not for us to tell authorized dealers how to deal with their obligations. So now let's look at what Circular 6 of 2021 said. But remember, it has been updated to a certain extent. So it confirmed immigration as a Reserve Bank concept was phased out on the 1st of March. All applications by an individual in excess of the single discretionary threshold require a tax compliance TCS PIN. And we assume that was the TCS PIN for foreign investment, FIA. And that's the sentence that was changed in Circular 8. So it was a very short period. Okay. Then on 21st of May 2021, Circular 8 says it removes the SDA privilege from persons having ceased tax residency, but they may, in the same calendar year as they have ceased to be a resident. Now that's not, we don't know if it's the physical transfer or the year that SARS acknowledged it. Transfer via an AD, authorized dealer, up to 1 million. Interesting, as a travel allowance without TCS PIN. Okay, so now no good standing required. You just need to tell the authorized dealer that you've tax immigrated. Some asks proof, others don't, because as long as you take it into traveling allowance, Most of them not to worry. But why? Because traveling allowance, interesting, unlike an SDA investment allowance, must be a rand-to-rand transfer. Okay, so remember that this is also a once-off dispensation and cannot be, and apologies for the spelling error, used in the subsequent calendar years. Very important also to remind everyone that one of the other confusions is the taxman works on tax years and the Reserve Bank works on calendar years. So your 10 million foreign investment allowance, your 1 million SDA or your traveling allowance is calendar years, not tax years. Private individuals ceasing to be residents for tax purposes only, okay, qualify for the aforementioned travel allowance and may not avail to the unutilized portion of the SDA. So they can't now transfer to dollars or pounds and go and invest money. But we do see certain ADs allow people in the year they've tax immigrated to convert and transfer in South Africa from rand to dollars. But it's also possible to actually, in subsequent years, even if you have not come back to South Africa, get another million. So if you leave in October, November, you can get the balance of your SDA as a traveling allowance, which is a rand transfer. Okay. And where your trip, you don't need to come back, then extends into, say, 2nd to the 5th of January, when the banks are really open again, you can now transfer another $1 million. So it is our experience that authorized dealers, and specifically the small exchange control dealers, grants SDA, so they actually report it as FIA and not a travel allowance, as they allow the funds to be transferred to a third-party bank account in a foreign currency. Strictly speaking, that transfer should have been to a rand-based bank account abroad. It's totally legal to have a rand-based bank account somewhere else, okay? And it can only be transferred to the traveler's own account. So for example, if you have these travel cards that some of the big banks issue, strictly speaking, that's what's intended. They can put it onto your travel card. That travel card is in rands. When you swipe it, it converts at that date to dollars, but you can't transfer in the year that you tax immigrate or after you have tax immigrated. You can't transfer your rands to a dollar account, okay? That is not allowed. So let's quickly compare Circular 6 to Circular 8, okay? And there's 2 slides on the topic. 6 of 21 said MP336 can only be done to February 2021. A TCS PIN foreign investment allowance for in excess of 10 million rand is possible, but it must go past the Reserve Bank. And that's why I get so annoyed. Some people call this the new financial immigration. What a lot of hogwash. It is just a Reserve Bank process. There's no more blocked funds. So please get your clients to understand that there is no more blocked funds. Financial immigration rests in peace. Blocked accounts became non-resident accounts, okay? And if you wanted to take that money out that's in the blocked account in the past, in the FE era, you could, as a couple, take 20 million without tax clearance. Now, unfortunately, you're back into the SARS system and you have to transfer that money in terms of a TCS PIN. So you have to get approval from SARS up to 10 million per individual, 20 million per couple, but then you must do 10 million on each taxpayer's name, not as in the past, on husband's name only. So we have a tremendous problem at the moment because many people did the formal immigration and opened a bank account in husband's name only. And they closed the wife's tax number because there's no more balance sheet items on her name and the chance that she would earn income was not there. Now, suddenly, if you want to do an FIA on the wife's name because you want to go back to the 20 million that they want to transfer out annually, you now have to re-register the spouse. The new rule was also retirement annuities. Remember, you could cash that out when you did formal immigration. And it's been changed to you must be non-resident for 3 uninterrupted years. And a TD, tax directive, was issued by SARS to the fund. Now that word years, you can highlight on your handout. Very confusing because is it tax years, is it calendar years, or is that a shorter period than a year when you tax immigrate? So for example, if you have immigrated on the 31st of October, your tax year is then, as non-resident, starts on the 1st of November, ends on 28th of February. So can you then be out 2 years and 4 months? Would that be adequate for the encashment of an RA? Some funds allow that. Others want you to be out physically 36 years, and 36 months, and others want you to be out physically 3 calendar years. So a lot of disputes about it. Then resident and non-resident assets, the rules were retained. Remember, they used that extinct word. So there was no change in that rule. So everything that was blocked became non-resident. So this is what gave us the idea that people that have tax immigrated will become non-resident, because it was just assumed that someone who has formally immigrated becomes tax non-resident because of an inferior tax immigration clearance. But as I said, that's a wrong assumption to make, and there's nothing specific in the AD manual that states that. Then in Circular 8 of 2021, around about May, it says, remember, Circular 6 was issued in the last week of February 2021, so it was issued at budget time. Then about 3 months later, they issued Circular 8 of 2021, and it says, AD may transfer assets abroad once TCS PIN TEC was obtained and tax compliant upon verification. That means on the day you transfer. Okay. Then in terms of B.2, a lot of complex references, but go to that in the manual. It says that all remaining assets subject to FIA may be transferred abroad. But if your assets, the transfer for the calendar year exceeds 10 million, you have to go past the Reserve Bank that does additional tests. The retirement annuity was further defined to say that lump sum amounts, okay, so when you encash 3/3, early encashment, then you must be 3 years non-resident, uninterrupted. Because there were some authorized dealers that, looking at the left hand on the 621 rule, said that benefits meant my living annuity. Remember, I explained to you that me that receives a once a year lump sum or single sum living annuity, I can take that out of South Africa, although I have not tax immigrated and although I have not exchange control immigrated, purely because I have a foreign address and a foreign bank account. So therefore, I'm a resident temporarily abroad. I'm therefore entitled to take it out over and above my 1 million single discretionary allowance. So 8 of 21 reconfirmed that. Then traveling allowance, TA stands for traveling allowance, in ZAR can be transferred in the same calendar year. And they then extended to say a no export process, NEP transfer, can be treated as cash if it was on your tax immigration clearance certificate. So for example, if you had furniture or shares, okay, on your balance sheet, then you can transfer that. Remember, there was years back when we did formal immigration, the so-called NEP form. That was for jewelry and gold coins and so on. NEP stands for no export proceeds. So now you can take out up to 1 million. Okay, so if you did not want to take out cash, you could now take out chattels, movable assets. So for many people, that was far more attractive than the cash one, because they could take grandma's jewelry out of the country, totally legal. But anyway, now we need to just summarize and get everything pulled together so that we understand the differences between 2021 changes and the 2022 changes. So the layout I'm going to follow is that I'm going to first deal with the 2021 circulars, and I will point out where they have changed, and then I will deal with the 2022. So the first one was the Circular 1, dealt with loop rules, and that's the one where I'm highlighting to you that we are anticipating an updated or change or revocation of the benefits. Circular 6 was partly withdrawn or changed by Circular 8. And then we have the Circular 10 and 11 becomes very important for foreigners or residents temporary abroad. So for example, Circular 11, that is the circular that allows me and many other pensioners to take their living annuity or pension fund out of South Africa, despite the fact that we have not tax immigrated, nor did we record ourselves as exchange control non-resident. Okay. So that is just a second part of the slide. Remember, we dealt a little bit earlier with the first part. Okay. So in Circular 6 of 2021, it says all new immigrated applications from the 1st of March must be dealt with by SARS. So that's why I say the Reserve Bank is abdicated. The question then remains, is it an easier or more complex system? All post-formal immigration assets are subject to foreign capital transfer rules, which means you need to get the TCS, FIA PIN, and if it exceeds 10 million rand, you must go past the Reserve Bank. Okay. Interesting, in that circular, they said natural persons resident and non-resident will be treated identically. I will later point out to you that residents are not treated when it comes to single discretionary allowance. We are not treated the same as non-residents. In Circular 8 of 21, it further stated that inheritances or life insurance up to 10 million can leave without a TCS PIN, okay, provided you're inactive on the SARS system. So there's a practical challenge for the authorized dealers, and the authorized dealers want proof of SARS, and SARS is not prepared to give that. In excess of 10 million, you must apply for a manual letter of compliance, okay? And the email address is on the circular. If I remember correctly, it's MLGS or something like manual letter of good standing, MLGS or MLOC at SARS. But it is on the system, and you'll also find it on the SARS webpage. It's less of a challenge, okay, at the Reserve Bank, and it is very quick once you pass the SARS step. So where it says less of a challenge, SARS very quick, it must read SARB very quick. For inter vivos trusts, income and capital distributions may be transferred abroad, subject to a TCS PIN by the trustees of the trust. Very confusing, but in practical terms, we now see that the trust on their tax number gets a TCS PIN. We are now allowed to do pre-inheritance foreign investments by donor. In the old days, when I took my 10 million rand out, I could not make it available to another South African or someone exchange control resident. Now I can donate it to another South African. Obviously, you must pay the donations tax, and they made it very clear in the 2022 circulars that it's subject to full tax compliance by both parties. Post-immigration assets, okay, the non-resident assets for the Reserve Bank, based on the TCR, which is the application form for the tax immigration clearance PIN, all the assets that listed on there can then freely leave. The Reserve Bank only needs a TCS good standing in the year you want to transfer. They don't ask for a new TEC PIN. So very important, the TEC PIN is only once off. Okay, so this answers, I had 3 or 4 questions from people prior to the webinar today saying, when I've got the TEC PIN, will my tax number be inactive? And can I then stop filing tax returns? And the answer is probably no. If you have any South African sourced income, you still have to apply. Have to file. Just remember, we file on a gross income basis. So even if you have interest income, you must claim that interest income to be tax exempt in terms of a double tax treaty. So therefore, the answer is yes, you must tax file. If you have no income, so for example, you only had a retirement annuity lying there, then it's best to submit those null returns, because at the time when the fund, the retirement fund, applies for a tax directive, SARS will probably decline because you have outstanding tax returns. I have recently seen one where there was no tax returns for 6 years, and SARS did issue the TD. So although the tax return showed on the e-file profile, someone activated them voluntarily, SARS did not officially issue the tax return. So very important, when does SARS officially issue a tax return? There's very unclear processes on the e-file because everybody has to activate a tax return for the year. But SARS issues normally this time of the year the government gazette saying who must file tax returns. And based on the information they hold about you, they may then call for a tax return. So quite interestingly, there's a rule that says if you have more than 250,000 Rand of foreign assets, you must file a tax return. And that rule does not state whether you're tax resident or tax non-resident. So in general, anyone who has foreign assets, because if you have foreign assets, it's most likely above 250,000 Rand, you must file. If you have taxable or gross income from rental properties, sorry, gross income, not taxable, gross, you must file a tax return. You are not a provisional taxpayer if the profit does not exceed 30,000. But for gross income, when you receive it, you must file a tax return. If you only earn South African dividends, then normally SARS does not call on you to issue to file a tax return. But if you earn any dividends that is not subject to withholding tax, then you're obliged to tax return and file a tax return. And then Circular 8, last point says, if the TCS PIN expired, a new application, okay, must be applied for. In the past, we were aware that people just refreshed the PIN and then used the new PIN letter to get further money out of the country. SARS, on one of the seminars I presented, challenged me subsequently, went to my RCB and said, I'm technically incorrect. We showed to them that on the old system, it was indeed possible to just refresh a PIN and get a new PIN for foreign investment allowances. As far as I am aware, I don't do those applications myself. That ability has been taken away. I've recently had someone call me and was convinced he could refresh it. I'm still waiting for his evidence that he refreshed it. But please do not refresh a PIN. They will report you to your RCB. RCB is the professional body that has granted you the tax practitioner status. Now we're going to, so we've now finished for 6 and 8. Okay, so remember when you go through it, 6 and 8, we have the basic rules and then we have the more specific rules. There was 2 slides. Then Circular 10 of 2021, that deals with post-immigration income transfers. You'll remember right in the beginning, I showed you the income transfer rule. That's where it comes from. So although I took it from the authorized dealer manual, this is the rule. Transfers of dividends, profits, and current income being net income, accruing to a non-resident and individual having ceased tax residency is freely remittable. Local liability, including SARS, must be dealt with, so therefore only net income. And all they need is a TCS good standing once a year. You do not have to do a TEC or tax immigration clearance every year. Furthermore, if you have done a formal immigration and you then, during that period, so you formally immigrated in 2006, and you did not get a tax immigration clearance. Sadly for you, the banks are now going to force you to get a tax immigration clearance. But now interesting is that I have recently been told, again, I don't know this a fact, because there was no tax immigration clearance, the authorized dealer argued that you have not ceased tax residency, and therefore they transferred the income as part of the single discretion annual allowance. So once again, a lot of abuse, and whether it's abuse or uncertainty, but people using the gaps in the system. Most important, Circular 10 says, transfer of pension and retirement annuities, that's the living annuity, can be paid to persons temporarily abroad, provided you have an own bank account abroad and a foreign address. So there's no requirement to prove tax residency. There's no requirement to prove good standing. I have seen recently when I did my pension transfer in September of last year, which was subsequent to that circular, that my bank did ask a TCS good PIN. I just accepted it because I needed the money to travel. I went to Dubai on the 1st of October last year, and my pension date is September. So I was quite happy to provide it because I had to provide it to my pension fund in any way. So it's normally immediately available, but strictly speaking, there's no real requirement that you have for living annuities. You need to have a TCS good standing. The reason for that is, remember that SARS deducts the pay-as-you-earn at source. I remain tax resident, so I can't claim pay-as-you-earn exemption on that. And secondly, you've probably all had that letter from your pension fund to say, in terms of the new rules, SARS have notified them that they're not going to deduct the table or read off the table. SARS have indicated to them the tax rate that they must deduct. So it was quite interesting. If I look at the tax rate that SARS instructed my living annuity fund or pension fund to deduct, it's still far lower than my marginal tax rate. I'm surprised about that. I would have expected to go for a higher rate, but maybe they're in a phase-in process. On that topic, if your client lives in Australia or New Zealand or England, and they have actually tax immigrated, do remember that you can apply to switch off the pay-as-you-earn completely. And we have seen that where people were given that pay-as-you-earn exemption letters, the SARS system has overridden that, done an override, and now instructed the pension fund to deduct. In a telephone call to SARS recently, they said resubmit that pay-as-you-earn exemption letter to the fund. SARS has in the meantime instructed the pension funds or the fund administrators that where there's a treaty exemption, their directive to deduct higher tax should be ignored. I unfortunately do not have that in writing. So if you have clients living in Australia, New Zealand, and England, and they have subsequent to getting the RST01 form stamped and submitted to SARS, if they have subsequently been told that there's an increase in pay-as-you-earn, they need to take action and phone their fund. Anyway, now I'm just going to stand. You'll see everybody may have asked me, you have skipped Circular 1. So I'm not going to give much attention to Circular 1 because its lifespan is limited. It's going to change. But let's deal with it, that we can all understand what is loop structures. So again, I'm very critical of the fact that there is no definition of a loop structure in the current AD manual. The best definition of examples you can get is to go back to the 2015-2016 special VDP publication by the Reserve Bank. But remember, that document also had a limited time span. So loop structures is now permitted for SA resident individuals, corporate, and private equity funds. What's the missing word? South African trusts. South African trusts cannot enter into a loop structure. Very important. So the expected revision we anticipate is that, and we base this on what we are seeing from ADs, whether the authorized dealers and FinServ is in alignment and they agree on all aspects, I don't know. Okay, so, but this type of sentence I've seen in multiple replies from various ADs. So I do think that this guideline comes from the authorized dealers, because remember, loop structures is not an application at the moment, it's a notification. You place it on record when the transaction is completed only. So I'm not sure if it was the authorized dealers being subject to an exchange control audit, or whether some of them still submits this to the Reserve Bank as an application where they were supposed to only file it as a notification. But anyway, the ADs are declining it, if that is indeed possible, but the letter says they are declined. The loop being placed on record because there's an opinion that Circular 1 of 20, and that's a typo, 21 it should be, was not intended to allow South African residents, individuals and corporates to restructure, re-domicile or externalize their South African assets to a foreign jurisdiction in any manner whatsoever. And that's the words that worries me, in any manner whatsoever, okay? And the control over and or the beneficial ownership of any existing local assets directly or indirectly owned by such a resident. The other big issue here is the word South African resident. Do they, when the AD speaks, are they now referring to an exchange control resident or a tax resident? Because remember, at the same time in January 2021, when this circular was published, the tax law changed so that there is no funneling of dividends at 5%. So the anti-avoidance rule in short reads, if a South African has a loop structure and they're using a treaty, so for example, from South Africa to, I think, Cyprus, UAE, Australia, there's certain dividends that can go at 5%. When that dividends then end up in the South African tax resident's name, you can't claim the participation exemption. You can't say, I now earn more than 10%, therefore the 5% was the final tax. The anti-avoidance rules effectively says, you will pay the top up of 15%, because if it was it not for the loop structure, you would not have been able to claim the participation exemption. So therefore, this any manner whatsoever is quite an interesting, wide argument, because if the intention was really in any manner whatsoever, why did they change the tax law? Surely the Reserve Bank realized. And that's why, if you look at the minister's speech in February 2020, when he said that he is going to allow loop structures, he said once the Tax Act has been amended. So even the Minister and National Treasury didn't go as wide as to say in any manner whatsoever. They anticipated there's going to be many whatsoever or manners whatsoever that they can't control. So the easiest way to say was, we're not going to put a brake using exchange control. We're going to tax you and bring in a tax collection on the abuse of the system. So again, on this one, we would have expected the Reserve Bank again to abdicate to SARS and for SARS to collect the additional tax where people are abusing the system. But at the moment, we're seeing authorized dealers. So I will be very worried if the Reserve Bank issues a new update and include the words in any manner whatsoever. The other one that is causing a problem, and there the reply is different. You can see it's each authorized dealer giving different interpretation, but the principle they are dealing with is the same. So remember, I said to you that capital for Reserve Bank and capital for Tax Act is not the same. So in terms of the Reserve Bank, on a company's balance sheet, retained income that was not distributed as a dividend, when the shares change from held by a resident to a non-resident, that retained income is treated as capital. So even in the days of formal immigration, if you wanted to transfer that that retained dividend, let's try again. If in the formal immigration era, you wanted to transfer the retained income out as a dividend on a date post formal immigration, you had to do a different application. You could, in the current year, send out dividends from profits after immigration, no restriction. But the minute you delved into the retained income, it was treated as a capital transfer, and you had to go past jail. So you had to do an application. So what is happening now is that in terms of the Circular 1, the transaction must be at market value or arm's length. So I'll give you an example. There's an offshore trust that had foreign assets for many, many years. It's not been created recently. Okay, so there was no malicious intent. The funds were abroad. And in Circular 1, they say that the intention of now allowing loops was specifically to allow South Africans to reinvest in South Africa. Now, if that foreign trust, say it's Family A's trust, they want to buy a company from me. When they buy the company, the shares from me, it must be at arm's length, whether we connected persons or not. The Reserve Bank rule doesn't refer to connected persons. It just says when a loop is created, it must be at arm's length. So now we value the company B shares. The company B shares must therefore, for capital gains tax purposes and Reserve Bank purposes, take into account the value of retained income. So let's say the company was dormant for that matter. There's no trade, but there was 1,000 Rand cash. Obviously, that company is worth 1,000 Rand. They pay me the 1,000 Rand. I paid capital gains tax on that 1,000 Rand. Okay, I only paid 18%, but I paid capital gains tax. When they now transfer that dividend, the retained income at the time they acquired, okay, that trust is normally in a jurisdiction where there's no treaty. So say it's in Jersey. There's a 20% withholding tax. So although I've just paid 18% on that 1,000 Rand value, that 1,000 Rand leaving as a dividend is now again subject to 20%. So SARS has now collected 38% on the same 1,000 Rand. Yet the authorized dealers want to tell us it's against the spirit of exchange control, because they say that that retained income is capital and cannot leave South Africa. Well, for that company who bought, it's not capital. It's not the same scenario as someone who has formally immigrated. That company has paid 1,000 Rand for that 1,000 Rand's retained income. They probably paid me 2,500 Rand because I would have asked the value of a company creation cost. The other option they could have done was to buy the shares from me for 1,500, the value of the company registration cost, but they bought from me ex-div, which means if the company declares a dividend, it still comes to me. The benefit of that is that the capital gains tax for me was far less. Secondly, when they then extract that dividend, it comes to me and I pay the 20%. Now I've paid the 38%. SARS has still collected 38%, and the South African has now paid only a dividends tax because I saved the capital gains tax on that value. Even those transactions declined by the bank, by the authorized dealers on behalf of the Reserve Bank. I don't understand why, because they are reducing the SARS CGT collection due to the value decrease. So some authorized dealers are trying to force us to sell ex-div. And I'm saying, no, allow us to sell cum-div, because the selling party in South Africa is probably going to pay 18%. And when the dividends get extracted, it's normally an offshore trust, and therefore another 20% is paid. Even if it's a company in Australia, it is another 5%, which would not have been paid if we sold ex-div. So I do not really understand this aggression from the authorized dealers, but let's hope that the Reserve Bank will bring clarity in an updated report. Then in one of the questions that was sent to me, they asked me to specifically deal with that circular 11. And this is now taken from the authorized dealer manual itself. It says residents temporarily abroad may receive pension and retirement annuities as mentioned in the manual under that section, as well as monetary gifts and loans as mentioned in subsection A. So now that I'm living abroad as temporarily non-resident, my mother or brother or sibling can send me R1 million on a loan account. They send it as a donation. Donation tax must be paid. But they can also mix and match that million, and it's R1 million per person sending. Okay, so this says abroad may receive. So if it's not their own monetary gifts, they can receive it from a mom or dad or sibling or as a loan. So if mom and dad each wants to send you R1 million, they can do that, provided they either pay the donations tax or you sign an acknowledgement of debt that you owe them the money. Okay. However, no other foreign currency may be available, okay, without specific prior approval. So I can take or receive the gifts from my family in South Africa, no restrictions. Over and above the R1 million from my parents, I can receive my own pension and retirement. And although it's not blatantly stated, if I then want to do an SDA, single discretionary allowance, I can sling my R1 million out as well. So as you can see, if I'm living temporarily abroad, let's say the UAE or the UK, you can probably receive close to 4 million to 5 million in value, depending on how many family members you have in South Africa. So there's quite a relaxation of exchange control to this extent, but you'll see that obviously SARB noticed the abuse in the 2022 year, and when we get to the 2022 rulings or circulars, you'll see that they specifically address that. And now we go back, so we jump a little bit back into Circular 10 of 2021, and that deals with testamentary and inter vivos trusts. An authorized dealer may allow the transfer of income to any non-resident. Okay. Now that is interpreted by everybody as non-resident for tax and non-resident for exchange control. Because remember, earlier we said that income transfers to people who have ceased to be tax resident is allowed, and to non-resident. If it's below 10 million, then the trust must file a TCS good standing. If it's above 10 million rand, okay, then we need a Reserve Bank approval. We have now seen that SARS is blocking that. So it's not exactly the next slide, but you'll see in a slide later that SARS and the Reserve Bank is now in discord. They are not agreeing with it. In addition, ADs may allow transfers of salaries and of fees payable to bona fide non-residents and private individuals who cease to be residents for tax purposes from South Africa, provided these individuals are unrelated parties to the company and the services are rendered from abroad. So I have my company in South Africa Tax Forum. I do not qualify for this because, first of all, I have not ceased to be a tax resident. However, if I decided to pay the exit tax, ouch the pain, and I become tax non-resident, then I can still not, without prior application, have my salary paid to the UAE or UK because I'm a related party. And this related party is a definition in the manual, authorized dealer manual, not the Tax Act connected party. Okay, so therefore, I am a related party and therefore can't take it out. If you want to take it out, so provided I have tax immigrated, then on my South African company's letterhead, you can do an application to pay the private individual who has ceased to be a resident, provided I have provided the service abroad. Now that's a bit of a double whammy because, you know, if you have tax immigrated, what is the chance that you are providing the services in South Africa, one would ask. But quite interesting is that once you're a tax resident in, say, the UK, okay, and you work for a UK company, SARS can't tax you on the income you earned in South Africa. When, however, remember in my situation, if I work for a South African company, I can't claim the UK treaty benefits. So every day I spend in South Africa, SARS has the entitlement to tax me. And the Reserve Bank and SARB is now in alignment. SARS says we're going to tax you. And the Reserve Bank says the salary for the month that I live in South Africa can't leave on the no tax clearance method. I can still transfer it as part of my foreign investment allowance, but I can't transfer it as part of SDA because remember, once you've tax immigrated, you cannot apply for SDA and have it transferred. Okay, so now we're into the circulars of 2022 and we're close to 3 o'clock. So let's take another break. This one is going to be a little bit longer. Let's make that until 5 to 3. So 14. No, let's make it 3 o'clock. It's 8 minutes. You can have a break until 3 o'clock. Good day, everybody. Welcome back. And here in Cape Town, we can feel that the sun is setting early, and now it's not just a hot cup of tea or coffee. Now we need hot chocolate. It's really quite chilly, so tonight we're going to have a cold night with the load shedding here in Sea Point at 6 o'clock. But yeah, that's the joys of living in Cape Town. Come summer, we'll be smiling again. So now we are going into the exchange control circulars of 2022. Okay. So in the pre-budget Annexure Fs, or Annexure F of the budget, SARS and Reserve Bank has issued a lot of documents. I'm not going to deal with all of them. There seems to be some conflicts between the Tax Administration Act and Reserve Bank on different levels. So, for example, it seems like the Tax Administration Act does not allow tax matters to be held on the cloud outside South Africa, where the Reserve Bank says we're quite happy provided you apply for that. So it doesn't really deal with our level of client dealing with clients, but just take note of the fact that if you are using tax filing software, that the Tax Administration Act says it must be on the South African cloud, where the Reserve Bank says the service provider can actually apply to have it done abroad, or the person doing the exchange control completions. Okay. So the first one that I just want to go back to is the section of the Circular 11 of post-immigration. Just remember that when you are living abroad as a temporary resident, it's the income that can go out. If you are a immigrant and you want to take your capital out, you know, the lump sums, you have not retired, you have not commuted yet, then you must be out for 3 consecutive tax years. And it is from the 1st of March is the application. But if you were out already in 2019, then your 3 years of 2020, 21, 22. So get your 22 tax return in as quick as possible so that you can take that lump sum out. Okay. So you will remember that we've seen in last year's circulars, that's the 2021 circulars, the Reserve Bank said that they're quite happy to see South African trusts, inter vivos and testamentary trusts, transferring assets and income to any non-resident. They didn't say private individual, they didn't say a company, they didn't say a trust. Then comes SARS on the 8th of April. It has been the SARS practice, okay, not law, practice, not to approve the release of funds when resident trusts makes distribution to non-resident trusts. Okay, so the issue is trust to trust, where the beneficiary trust is non-resident. Following numerous queries in this regard, SARS herewith reiterates its stance on the matter and herewith confirms that it will not approve the release of funds vested and distributed to a non-resident trust. It's an interesting. I'm challenging, although for the rest of the issues with exchange control, I'm really feeling sorry for SARS. On this one, I'm very honest. I think they are outside of the Tax Administration Act. This is not for them to decide, and there's nothing in the Tax Administration Act that says SARS can stop any transfer. SARS has an obligation to say the trust is compliant or non-compliant. It has an obligation to say the beneficiary is resident or non-resident. That's it, nothing more. They do not have this right. I humbly or respectfully submit. Then it says SARS is currently investigating other options related to the distribution of funds amounts to non-residents. And in discussion in this regard, SARS takes note of the fact that the SRB has relaxed certain exchange controls. So the second paragraph is even more alarming, okay? Currently investing other options related to distributions of funds amounts to non-residents, okay? Based on the risk involved, not to approve the release of funds to non-resident trusts. So they start off by making it wider, all distributions, but in the last bit says not to approve the release of funds to non-resident trust. I have 2 cases where the beneficiaries are actually non-resident companies. Okay, they are foundations in terms of Dutch law, but in Dutch law, a foundation is a company, not a trust. And SARS also refused to transfer. Do note that, for example, in Mauritian law, a Mauritian trust quacks as a company. They don't really have a distinction in tax law between a trust and a company. This, however, does not preclude a resident trust from vesting amounts in non-resident individuals. There's your comfort. And to apply for the relevant approvals as per the current approved practice. Now, I don't know what's the current approved practice because we've seen no practice note or interpretation note. The Reserve Bank, and that's how we have been dealing with our clients, we get a TEC, tax immigration clearance, to show the beneficiary, the individual, is living abroad and tax non-resident. And we get a TCS good standing PIN from the trust or in respect of the trust. And there the money flows. So, and where it is a deceased estate or a inter vivos trust, we submit proof of the master's documents or the liquidation and distribution account. Okay. So I'm not too worried about the individual. So I don't know if any one of you have alternative procedures in place, but that is what we are doing, and the authorized dealers seem to allow the transfers out. I must be upfront to say that I've never been asked to really transfer money from a South African trust to another foreign trust. As I said, mine was to distributions to Dutch Foundation, which in Dutch law is a company, and even that was not allowed by SARS. The Reserve Bank has given us a letter stating it can be done. Obviously, we can't get a tax immigration clearance, and that's where the problem comes in. We can't get a tax immigration clearance for the Dutch company because the Dutch company has never been in South Africa and they're not keen to register in South Africa. And the question begs, if they come and register with SARS to get a tax immigration, what a joke, clearance certificate, then they may be forced to do a sub-C registration, all too cumbersome. So yes, unfortunately, discord between SARB and Reserve Bank, and it is a debate to be followed. So here is the Reserve Bank exchange controls for 2022, the circulars that I'm going to deal with. You'll see that there's certain gaps. So number 2, we've quickly dealt with the offshoring and cloud computing, not that important for us today. Circular 4 is just a repeat of the Annexure 4, so I'm not really going to go into detail on that one. Number 5 deals with resident individuals, not just non-residents. Number 6 is a scary one. That's the Bitcoins. 7, retention abroad of foreign gifts and authorized assets. That is a change to the Circular 1 of 2021. And then capital transfer by resident individuals. As you can see, 2022 is more relaxation in respect of resident individuals, exchange control resident individuals, where 2021 was more a change, if not a relaxation, in respect of exchange control non-residents and person who has ceased to be tax resident in terms of the tax system. Circular 11 relaxes the foreign direct investments and the DTMC rule. And number 13 deals with post-tax immigration, and this is the first one and the only one that really deals, the first one that really deals with expats, okay? And that's the once off 100,000, okay? Remember, in 2021, they took away the 1 million and they very nice to replace it by 100,000. Somehow the sums don't add up, but they are very happy with the new relaxation. So Circular 4 of 2022 says, it's the SARB statement of exchange control. They just mirror or replicate what National Treasury said. So what they are doing is placing National Treasury statements in the national budget on record as SARB policy, and then they refine it in the subsequent circulars. Can you see why I'm saying that, why I'm blaming National Treasury for the confusion that's reigning? Because the Reserve Bank just rubber stamps everything that comes from National Treasury. So the circulars thereafter is a bit more in detail. Okay. So Circular 5 of 2020 says we can now export multi-listed securities. So previously restricted to individuals that cease to be a resident could transfer their dual-listed shares or foreign-listed shares from a South African share register to a foreign share register. Now, any resident may avail to either the single discretionary allowance or the FIA to export or transfer shares from a South African exchange to a foreign securities register. Okay. So, for example, if you have any shares that are dual listed and it totals 11 million, you apply for your 10 million, you then present your SDA 1 million and ask your authorized dealer to, in lieu of cash, transfer those shares. Okay. Then the South African share register must allow for that transfer to the foreign register. Very, very attractive option, because remember, in the old days, I had to sell the shares, trigger capital gains tax, and buy new shares on the, say, London Stock Exchange. Now, I do not need to dispose of the shares. So I argue not triggering a capital gains tax. I've had some of my learned colleagues saying that if you look at what a disposal is a change in the nature of an asset, they say the change in the nature is from a restricted asset, blocked asset, to a non-restricted asset. I'm not so convinced, because remember, blocked accounts was abolished, okay? So it's just from one register to the next. So I'm not convinced that that definition of disposal in the CGT rules, that's the 8th schedule, really covers this position. So my argument is that if you follow this process, you get the right to transfer your South African assets to a South African held assets to a foreign base, and you will not trigger capital gains tax. But then if it exceeds 10 million, you can also do that. So there's no restriction. And you just have to go to the Reserve Bank, and they want to ask the source of funds, how long you've had these assets. If you had it for multiple years, then obviously no problem. And if you're not in the Zondo Commission, and I think the fine report is today, so expect a few people to have some challenges as of today to get money out of the country. But very, very important, can you see, and I was publicly attacked the other day on Facebook when I said the 10 million is a glass ceiling. This statement says a South African resident, exchange control resident, and then also tax resident, can transfer more than 10 million in equities from a South African stock exchange to a foreign stock exchange. Furthermore, we'll see later that the previous requirement that you have to keep that shares in your personal name has been abolished. So if you want, you can trigger a capital gains tax, and once the shares are on your own name in a foreign stock exchange or foreign securities register, you can transfer it from your personal name in specie into a foreign trust. But just remember, then you trigger capital gains tax, and you then face all the Section 31 and Section 7(8) anti-avoidance rules. This one is extremely important. This rule says, including in the restrictions are any trading of global currencies, trading of contract of difference, CDS, trading of foreign stocks, trading of commodities, and then they say including cryptocurrencies, which I find very strange, because both the Reserve Bank and SARS has nearly 18 months ago agreed that the new word and definition is crypto assets, and trading in foreign indices using the online platform or brokers of the foreigner. You may use your single discretionary allowance and your FIA, provided the authorized dealer convert the ZAR, the local currency, into a foreign currency in South Africa. So you can send dollars out. But you may not fund the international trading account, albeit at a registered broker using a South African credit, debit, or virtual card. May not fund the international trading accounts, okay, at a registered broker using SA credit or debit cards. Now, someone sent a question about Luno. I must be honest, I do not have cryptocurrencies. I just don't believe in it. Don't laugh at me, it's just my personal opinion. I'm gray bearded, so I'm very reluctant to get involved in that. So I can't answer. They asked me, can a Luno account now be funded using your SA credit account? Because Luno is a South African company. I don't know. If I read strictly there, even a registered broker, if you are converting to a wallet with Luno in dollars, my fear is probably not, then you must use your SDA or foreign investment allowance. You can no longer use your credit cards. If there's anyone with a Luno wallet and they're transferring from South African rands, you can probably tell us what your banks are allowing authorized dealers. So these changes came about on the 23rd of February. So anyone since the 23rd of February until today, if you have used your South African credit or debit card to fund a Luno wallet, please guide us. I know Luno is not the only one, but the inquiry came in from someone who has a Luno wallet. Okay. So I'm using the word cryptocurrency because the Reserve Bank used the word crypto currency, but we do know for tax purposes and all other financial acts in South Africa, we are dealing with crypto assets. Okay. The AD manual does not allow for cross-border or foreign exchange transfers for the explicit purpose of purchasing crypto assets. So very important, you cannot apply to buy foreign crypto. So if you fill in the FIA form, if it says that what you're going to buy, you are buying cash, you're going into a cash account, you can't say crypto, okay? Not that they will disallow it, but there's no specific permission to buy crypto assets. You get permission to do a FIA, to invest in a foreign bank account, or foreign property, or foreign shares, or to advance it to a foreign trust, okay? So it would be advisable that you open a foreign bank account to stay clear of any aggression from the Reserve Bank. So from an exchange control perspective, the FinServ department is unable to prove, and this is quoted exactly from the SARB webpage, okay, are unable to approve transactions of this nature. So they won't not approve your 10 million transfer, but they won't be able to approve your transfer from rands to a crypto wallet. You must take it from rands to a foreign currency, real currency, dollars, and from dollars you can take it into the crypto, okay? And the residents are permitted to make permissible foreign currency payments for small transactions, okay, by means of credit or debit cards. But that transaction is limited to 50,000 per transaction. In the past, it was per day, but it's now transaction. But any singular transaction exceeding 50,000 may not be split to circumvent the limit application, okay? But that 50,000 may not be used to buy crypto. So I'm arguing, if your Luno wallet, and I don't know what the Luno wallet is denominated in, if your Luno wallet is in dollars, then I don't think you can use your credit or debit card or virtual card, okay? The next one, very, very important. It's not permissible to play online lottery, online trading, or buy cryptocurrency with any South African debit or credit card, okay? So included in that is NFTs, non-fungible tokens, those kitties, and the artworks, crypto assets, okay? But please take note that lottery is slipped in there. But lottery has always been there, so it's not a new addition, okay? So you cannot buy your South African lottery. But I'm a little bit worried because although that circular now refers to buying lottery on credit card, I'm just reminding you that the old rules, the pre-existing rules in sub F of the AD manual reads as follows. Residents may not participate in lotteries organized abroad because you contravene the Lotteries Act. So that sentence doesn't say you're allowed to use your UK HSBC bank account to play the lottery in the UK. It seems, looking at that from what I can read, and I'm an accountant, not a lawyer, is that it seems like the Reserve Bank is restricting you participating in any foreign lottery. In terms of the National Gambling Act, as amended by the 2000 Act, residents may not participate in any gambling activities not authorized in terms of the aforementioned act. That's what reads there. So if I fly to Las Vegas, am I allowed to gamble or not? I don't know. Probably just rather draw the cash at an ATM machine, pay terrible exchange rates, but don't use your South African credit or debit card to fund that lottery or gambling machine in Las Vegas. Accordingly, authorized dealers must decline requests to purchase foreign currency for such purposes in all instances. Okay, so that seems to indicate that if it comes from a South African debit or credit card. So that is why I'm saying don't play or don't gamble in Las Vegas using a South African card. But it seems that my interpretation as an accountant, as long as you're not requesting the purchase of a foreign currency with the purpose of gambling. So if you bought R1 million of dollars and you only got $80,000 and you spend some of that $80,000 cash on a gambling machine in Las Vegas, you're probably okay. But please, if you use a travel card, the South African travel card that was issued to you and you've put that R1 million on your South African travel card, don't swipe that card at a gambling machine in Las Vegas, okay? Because although you're outside of the country, it says residents may not participate, Then finally, number 4, and that's the change, residents may not use their credit or debit cards in South Africa to facilitate payments to the above mentioned purposes. In addition, all issuers of American Express, Diners Club, MasterCard, and Visa cards may not accept such debits against resident cardholders' account in respect of payment for foreign lottery tickets or online gambling tickets. Okay, so although the sentence is very confusing, residents may not use their credit card, debit cards in South Africa to facilitate payment. It doesn't really say that you can now fly to London and swipe your debit card or credit card in London playing a UK or the very attractive Euro lottery, because it says, in addition, over and above this previous restriction for use in South Africa, the issuers of these cards may not accept such a debit against resident cardholders in respect of payments for foreign lottery tickets or online gambling. So I think the last part of the sentence makes it illegal to use your South African debit or credit card anywhere in the world for gambling. So please be aware that if you want to gamble, just don't use a South African credit card. And if you really want to go and gamble big time in Las Vegas, maybe just get a legal lawyer's appointment, advice. I can't exactly tell you, but from a Reserve Bank perspective, as it stands there, it appears that there's a blanket prohibition against that. Circular 7 was a very interesting one because this amends Circular 1, and very interesting. Normally, when this happens, then they withdraw Circular 1. But as we haven't seen the amendment to the loop structures, they have not officially withdrawn Circular 1. So of 2021. So Circular 7 of 2022 does amend Circular 1, effective from 23 Feb 2022. So it says they're subject to local disclosure and compliance by both the donor and the donee. So from my understanding, it's for capital gains tax and donations tax, but it could probably also be Section 7(8), the anti-avoidance cross-border rule, if you are donating to a child or friend or someone living inside the UK. So you can now keep foreign assets inherited from a local estate. So let's quickly distinguish between that. I'm living in South Africa. I took my 10 million out of the country. When I pass away, that is authorized assets, it's regularized, up till 23 September. No, that's right, 23 February. Up till 23 February. If a South African inherited that legal assets held abroad from me as a South African, then that person had to bring the money back or do a special application to keep the inheritance abroad if it was, say, a property. As of 23 February 2022, no further application required. And furthermore, if you held any assets authorized, you may now advance or dispose it to a local resident, which means I can now advance my dollars to my sister. Or dispose means I can donate that asset to my sister, albeit that she lives in South Africa. In the past, that was not allowed. If you are living in the UK, okay, and you are exchange control resident, but not tax resident. If you are donating that asset, the UK says there's no donations tax. If you die within 7 years, they're going to recoup part of that proportionally as a death duty or AHT. The recipient sitting in South Africa is tax-free, no donations tax, agreed. But remember what they said, subject to local tax disclosure, not tax payment, disclosure. So therefore, if you are now receiving a foreign asset, whether there was donations tax paid on that or not, you as the recipient, the donee, must declare that on your South African tax return. No question to be asked. And remember, we have all escaped that. And remember, the other problem is that up to now, we've all agreed that if the donation was less than 100,000, you didn't need to file an IT 144. But now it puts an obligation to you that there must be full tax disclosure. So someone said to me after I presented this very similar seminar to another group, that they feel that you have to file the IT 144, even if the donation is below 100,000 Rand. So that's important. I didn't think of that one, but I'm open to suggestions. It also amends the immigrant compliance. Okay, so for example, if someone comes into South Africa and he now lives here as an exchange control resident, and it was assets he held outside South Africa. So in the past, that person had to sign a declaration on immigration to the authorized dealer saying that I hold assets outside of South Africa and I undertake not to make it available. We have not seen the declaration forms being updated, but they are no longer restricted, not providing it to other South Africans, but they have to also comply and report that to the taxman. Again, that donation made is free of the nation's current tax law. So therefore, even an immigrant, someone who came into South Africa donating assets that he held before he came to South Africa and it's donated, he has to comply with that. The 23 February change does not go backdated. If there was any past transgressions, you have to do that. Okay, so let's look at what the manual says. It says any foreign assets received by a resident from a non-resident as a gift or donation on or after 23 February is exempted from the provisions of Regulation 6 and 7, which means you have to bring it back or ask permission, subject to local disclosure. So even if you now receive a donation from an aunt or an uncle living in the UK or Germany that's never lived in South Africa, you can keep it there. But if that donation was prior to 23 February, you have to still regularize it and apply for exemption. Okay. So my past experience is that foreign parents of immigrants or immigrated parents of residents often start donating during their lifetime. Because remember, in the UK, they have this interesting rule that they can donate. Donation tax-free in the last 7 years, or if they donated in the 7 years prior to death, there's a partial recoupment for death duty. So it became very attractive for people living in the UK to rather donate pre-inheritance donations to South Africans. And in the past, South Africans didn't report it for the taxman, they didn't report it for the exchange control, and suddenly when they transferred the money in and the bank started asking where this money comes from, then the Reserve Bank slapped us with a 40% penalty because that was not reported. So please, this new rule is on the 23rd of February, 2022 going forward, not going backwards. Okay. Then Circular 11 of 2022 deals with foreign direct investments. Okay. So foreign direct investments restrictions of in excess of 1 billion now only applies to foreign direct investments in excess of 5 billion. So if you are going outside the current business lines of the South African company, then the application must go to the Reserve Bank, provided it exceeds 5 billion. Below 5 billion, your authorized dealer can apply for that. Okay. And now comes the interesting one. Circular 13 of 2020 says, it only impacts residents that has ceased to be tax resident. So whether you're exchange control resident or not, irrelevant. If you have ceased to be a South African tax resident, you are not allowed to take money out of South Africa in the calendar years subsequent to your tax immigration. Now they say, as a once-off dispensation, where an individual has ceased to be a resident in South Africa for tax purposes and has a total remaining cash balance not exceeding 100,000, the AD concerned may remit abroad on a once-off basis, not an annual basis, the remaining cash balance without reference. So very important. If you have more than 100,000 and it's at different banks, you do not qualify for this new relief. Furthermore, if you want to apply this and it's 100,000 or less, the remaining balance must leave. So it means you must close your bank account. Okay. And you must make sure thereafter that your tax profile becomes inactive, so that if you then later inherit an amount of 10 million or less from a South African, that money can freely flow. But please make sure that if your clients are using this new rule, that they transfer the remaining balance. They can't keep the bank account open and only transfer 80,000 of the last 100,000. Also, if they have 120,000 rand in the bank, they can't now transfer. Okay, so before they do the once-off transaction, maybe let them spend, let them pay the South African exit taxes, do the VDP, pay your fees. Now their balance dropped to 95,000. And after the SARS VDP has been approved and the tax immigration is on record, then they can transfer. And this 100,000 unlike the travel allowance, can be paid into a foreign currency or foreign bank account. But 100,000 compared to R1 million removed, that is very, very small exchange control relief, but it's there. I'm seeing this being abused on a daily basis. And I've come to the point where I'm actually telling authorized dealers I'm going to report them to the FIP because they're not doing their duty. Yes, I understand there's no obligation on them to make sure that the client has no, or doesn't have a second bank account and therefore cash of more than 100,000. But I've just had a very prominent bank transfer only the money held in the call account, which was 100,000. That so happens to be, ignoring the fact that in the check account is 400,000 rand. And if I read this clearly, it says, and has a total remaining cash balance, not on the account, a total remaining cash balance. Okay. So there's the rules. Okay. The other important part that I want to point out to you is, in addition to the monetary gifts, residents may export Kruger Rand coins or the equivalent of a fractional Kruger Rand coin up to 30,000 as gifts to non-resident, subject to the completion of the prescribed SARS custom declaration. Okay. So over and above your R1 million, if you really have some extra cash, you really want to send your child another amount, you can send him Kruger Rands, okay? And we assume this is per calendar year. It doesn't state that because the Reserve Bank treats everything on a calendar year basis. And the X part, the number 10 part, says authorized dealers may allow residents, that's individuals, to transfer a monetary gift and loans within the single discretionary allowance, which is an annual calendar year allowance of R1 million, to a non-resident individual, okay, a non-resident individual, and to individuals who are overseas temporarily. So you don't have to tax immigrate, okay? Excluding to those people that's abroad. So you can't send your child to London, go and have a holiday, daddy sending you 30,000 rand of Kruger Rands, and mommy sending you 30,000 of Kruger Rands. Yeah, don't laugh. 30,000 has been on the books there for many, many years. It's really a very low monetary value, okay? There's the gifts, okay, and it says authorized dealers may purchase foreign bank accounts from residents who receive the bank notes from visitors to South Africa as a payment for services rendered, gratuities, tips, or gifts. I so often get the question, people say to me, you know, I was running this little Airbnb and the guys paid me for the extra nights and dollars, and now I've not cashed them because I'm too scared to go to the bank, and what do I do with this? Can I fly out with this? Absolutely no excuse. If you are a resident, okay, this is specifically for residents, the authorized dealer may buy that from you. They are going to question you to death, let's be honest. But I promise you, if you have a letter from or an invoice made out to your Airbnb guest, then the bank is going to clear it. Their obligation is to see the source, okay? If you're a waiter, just get a letter from your employer to say you're a waiter at the restaurant and your client or the person that dined there, the diner, paid you a gratuity or tip in a foreign currency. Okay. Then at the bottom, I just repeat the changes now. Remember, we had the changes already in Circular 11 of last year. Now it's again updated, and it says residents temporarily abroad, like myself, working in the UAE 6 months a year, may receive pension and retirement annuities, as well as monetary gifts and loans, as mentioned in section A10. However, Roman 10, no other foreign currency may be availed without specific prior written approval of FinCEN. So it's above my single discretionary allowance because it's the single discretionary allowance of my parents, okay? Then gifts does not include trust distribution. Remember, a gift is a donation, but with regard to pre-inheritance gift, such assets may also, or funds may also be transferred abroad, subject to the TCS process being completed by the resident donor. So even if you want to donate to your child that's living abroad, okay, more than 10 million rand, again, the 10 million is just the glass ceiling, that requirements of Roman 7 would mean that you have to go past SARS, and once past SARS, you must go to the Reserve Bank. They're going to check that you're not a terrorist, you're not on the anti-money laundering list, and that you are not listed in the Zondo Commission as having funds of questionable source. Then someone asked me about the blocked funds. So this was just an easy place to put it. All assets that were previously blocked, okay? So your blocked accounts, whether it was double blocked, single blocked, triple blocked, I don't care. Any amount that was blocked may now be dealt with as follows. In respect of income and capital distributions from an inter vivos trust, such distributions may be transferred abroad subject to a TCS process being completed by the trustees. Okay, so the trust must have a TCS good standing. For any transfers above 10 million, the requirements of 7 must be complied, so that the source of funds and the trust, and we see the Reserve Bank also look at the recipient's name. But very important that this distributions is over and above your FII. So a trust distribution is not part of a gift, okay? So if your dad gave you 10 million and he sent it to you in the UK, it's dad's foreign investment allowance. You can still do your own 10 million foreign investment allowance, plus the trust can give you another 10 million. So you can take out 30 million by just using SARS processes, okay? So please do not confuse the gift rules with trust distribution rules. But note, if the beneficiary of the South African trust is a foreign company or a foreign trust, SARS may stop that. Okay. Then, very important, on the single discretionary allowance, residents, natural persons who are 18 years and older, may be permitted to avail to a single discretionary allowance with an overall limit of 1 million without the requirement to get a TCS pay. There's absolutely no requirement that you even have to have a tax number, but we see some authorized dealers do ask, which may be used for any legal purposes abroad, including investment, as well as the sending of gifts, parcels in lieu of cash, but excluding gold and jewelry. So just remember, your gold and jewelry falls under the 30,000 exemption, okay? And if you tax immigrate, you can take your jewelry out, but not the Krugerrands, unless you get specific permission for Krugerrands. I have had success with that, specifically where we could prove that Krugerrands were bought many, many years ago. So it was not bought with as a way to overcome monetary restrictions in the Exchange Control Manual. Okay? And authorized dealers must ensure that the purpose for which the funds are used abroad must be reported under the correct category. So take this back to the people that have tax immigrated. Now we see the authorized dealers are sending R1 million into dollars, and they report it as a SDA foreign investment, but the person is tax immigrated. Again, there's no correlation or no double check that we are aware of by the Reserve Bank to make sure that anyone who has used the SDA foreign investment code is indeed tax resident. So capital distributions from a local testamentary trust due to a non-resident, and you see it doesn't say trust, it doesn't say company, it just says to a non-resident, may be remitted abroad, provided the trustee's resolution confirming the capital distribution, okay, and the last will and testament confirming that the beneficiary is entitled to such capital distribution have been viewed. So don't try, if you have a testamentary trust where mom is the income beneficiary and you are the capital beneficiary, you can't now send the capital assets out to mom. You can only send income out to mom, provided she has tax immigrated. Distributions as a result of enunciation of a beneficiary's right to a capital testamentary trust must be referred to the Financial Services Department. So don't even then try to ask mom to just waive or donate her income right to you. First of all, Financial Surveillance Department is going to make sure that mom has paid the donations tax, because yes, there's a donations tax on the waiver, because that income right that she has, that she waives as a personal right, and that constitutes an amount donated gratuitously, because before that asset can leave South Africa, she must waive her income right. Income due to non-residents and private individuals who cease to be resident for tax purposes. Income from trusts. Now, it doesn't say inter vivos trust or mortgage cards or testamentary trust. It then says, A, trust created in terms of a last will and testament, mortgage cards one, authorized dealers must or may allow the transfer, but for inter vivos trust, okay, they may also allow, But in respect of both, whether it's a testamentary trust or an income trust, inter vivos trust, authorized dealers must require TCS good standing from the trust at least once a year, or on application up to 10 million rand. But if it's in excess of that, okay, then TCS foreign investment allowance must be done. Okay, so it is very difficult. Now, this is the typical one where a trust cannot get a FIA. So therefore, if it's above R1 million to a specific individual, then let the 10 million go out without FIA. You do a TCS good standing. 10 million goes out. Then the trust distributes cash to a South African bank account, and now the individual can transfer the balance above 10 million under his 10 million allowance as foreign investment allowance. Because although the Reserve Bank states that the rule applies that above 10 million it must go past the Reserve Bank, you can't get to the Reserve Bank until you have a foreign investment allowance application approved. And the Reserve Bank, the SARS, will not issue any FIA to a trust. Okay. So this is the general rule on anything above 10 million rand, because I've just referred to it, but this is it so that you know what it involves. FinServs will consider applications by private individuals, resident or non-resident, who wish to invest in excess of 10 million rand foreign capital allowance limit. That is capital transfers, ignoring your 10 million income transfer you can do if you tax immigrate. In different asset classes, such investment, if approved, could be facilitated by a foreign domiciled and registered trust. Now, I don't know about you, none of the Channel Island trusts are domiciled and registered, so I think they should have used the word all, but that's very technical. This dispensation would also apply to private individuals who have existing authorized foreign assets. So people who have existing permission to go over 10 million, they can now ignore the old letter that was issued to say that it's subject to them investing in personal names. So someone then sent a question and said, do we have to stop with the annual reporting? And as I said right in the beginning, I'm not sure. There's no obligation in the manual for continued reporting. But remember, you are subject to the interpretation by the authorized dealer who facilitated the transfer out. My personal submission is that no further requirements, okay? Because now the transfer is subject to Reserve Bank approval. Thereafter, how it's dealt with is no longer required. So the question was, do you still have to report when you tax immigrate? I'm saying you don't have to report, from what I understand here, whether you're a resident or non-resident, okay? So tax immigration is not really required. I'm saying that reporting is no longer required. Do remember that this information will go to SARS, because remember, you have to go past SARS to get the 10 million or in excess of 10 million. So do expect some questions from SARS in the future to report the income. But the inquiry, I think, referred to the obligation to annually report to the Reserve Bank the value of that portfolio. Remember that letters originally said that that assets will be treated as part of your local assets, which meant if you tax immigrated, you either had to bring it back and take it out under the 20 million per year rule, or you had to get special permission to retain it abroad. All that part of the authorized dealer manual has been scrapped, and they have not replaced it with new restrictions. Okay. Then also note, to verify taxpayer compliance in the SARS e-filing system, authorized dealers should note that TCS PIN can expire, and should the authorized dealer find that the TCS PIN has indeed expired, then the AD must insist on a new TCS PIN. Now, that is the problem. On the SARS system in the past, we could just refresh that and we got a new PIN. So that's still possible for TCS good standing. But the foreign investment allowance, as far as I know, after my previous presentation to this group, SARS came back. Yeah, so SARS, Danny and Stan is actually listening to these seminars, came back to me and said, it's not legally allowed. And I said, well, it's legally possible, or physically possible on the e-file system. As far as I know, that has been terminated. Okay. Then just remember, if you have a family member, so now remember, I'm going back to this where the South African trusts are distributing to a foreign or non-resident beneficiary. When you do that, you are triggering other exchange control compliances, because when a discretionary trust transfers 1,000 Rand or 1 Rand to a foreign beneficiary or non-resident beneficiary, that trust is now an affected company, okay? Because it refers to a trust as an affected company when more than 75% of the beneficiaries is able to receive the money. And in a discretionary trust, the Reserve Bank treats it to say that it is possible and able to distribute everything to one, being the foreign beneficiaries, okay? The other problem we have is that ex-con refers to a trust operating in South Africa. Now remember, when we had the 2003 tax amnesty, and specifically after 2001 capital gains tax changes, we now see a lot of South Africans effectively managing their foreign trusts in South Africa. Why are they doing that? If they distributed that asset to them in South Africa, then the interpretation note says that they are taxed on that capital gain, okay? Interesting, if you then bring that trust into South Africa, foreign non-resident tax trust, you bring it to South Africa and it becomes a tax resident trust, there's a step up in base cost. Not tax, but there's a step up. It's an immigrant, it has a new base cost. When that trust then distributes to you, it's for tax purposes, a resident trust. And then you pay capital gains tax on the growth between tax immigration date and distribution date, and you escape that tax. Okay, so we have a situation where many foreign trusts are operating in South Africa, and we don't exactly know what the Reserve Bank intends with that. There's a dispute whether those foreign trusts need to be registered with the Master of the High Court. I'm just saying to you, do note that any South African operation of a trust will trigger exchange control rules as if the trust is resident, and therefore SARS tax number, TCS PIN process is advisable. Let's make it very practical. In 2003, Daddy took the amnesty and he brought the trust onto South African tax register as effectively managed in South Africa. He had 2 children, one of them yourself in South Africa, and the other one your brother, now living in the USA. Over and above the throwback tax trust rules that's applicable in America, we now have the problem. If that foreign trust operating in South Africa wished to distribute foreign money banked in England to the child in America, it is my submission that that South African exchange control trust, tax resident trust, but domiciled in the Isle of Man, need to obtain a SARS TCS number to distribute. Now, there's no hurdles to overcome because the Bank in England or the Channel Islands are not even aware of this rules. But if you're the trustee and you are effectively managing it in South Africa, it's you. Remember we said earlier that residents with foreign assets, the foreign asset is not subject to exchange control, but the owner, the resident, is subject to exchange control. So I'm just reminding you where we started. See the full circle we're making. I'm now applying rules, and I'm now as guilty as the authorized dealer. I do my own application and interpretation. The other part is that, important to note, is that partnerships operating in South Africa, okay, must also be treated as an exchange control, subject to exchange control. Okay, so I'm ending off at the bottom there. Foreign trusts effectively managed from SA, that's SA tax resident, but as there's no South African trust, it may not have a master's registration number. There was a tax benefit in bringing that trust on shore, but I'm saying to you, the new changes of 2022 obliges you as the South African resident trustee to obtain a TCS PIN good standing before you distribute a foreign asset to a non-resident beneficiary. And having distributed from a South African trust that's with the master, registered with the master, to a non-resident beneficiary, you have immediately implied that that trust is an affected person. Because an affected person means any body corporate, foundation, trust, or partnership operating in South Africa. So therefore, I'm saying to you that that trust that is operating in South Africa but not registered in the master is also subject to exchange control, will be an affected person and have borrowing restrictions and must report to the Reserve Bank when 75% or more of the capital, the assets, or the earnings thereof may be utilized for payment to or the benefit in any manner of any person who is not resident in South Africa. So the minute one beneficiary of a discretionary trust lives abroad, it's Reserve Bank interpretation that 75% is ticked because it's able, okay, may be utilized for the payment of that person only. And the last one, or 75% or more of the voting securities, voting power, power of control, capital assets or earning thereof are directly or indirectly vested in or controlled by, on behalf of a person who is not resident in South Africa. Now, there, unfortunately, they don't say assets in South Africa. So if it is a trust operating in South Africa, and the voting securities, so the 2 trustees out of 3 trustees on the Isle of Man, then you're 66, you're quite okay. But if you look at the discretionary nature of that trust, then again, that assets can directly or indirectly vest in or controlled by a person not resident. Therefore, the minute it's an Isle of Man discretionary trust and there's one of those beneficiaries outside South Africa, and that trust became a tax resident because of a tax amnesty decision in 2003, I do fear that you now have exchange control problems. I have dealt with all of these, but the most important one on the right-hand side, in cases where the total assets of a resident estate is less than 250,000, cash bequests and the cash proceeds can go out directly. So if you have an 183A estate where you do not have to file an LND, if the total assets in the estate, not the foreign assets, is less than 250,000, you can send that 250,000 or whatever amount is required to the non-resident individuals, okay, or non-resident trusts. So it's interesting, this transfer is not being stopped by SARS. SARS only stops the transfer from a South African trust to a foreign trust. Estate assets to a foreign trust is not stopped by SARS. In all cases where such resident estates hold authorized foreign assets, distribution of the foreign assets may be affected to non-resident, provided that all the foreign administrative and related costs have been met from the foreign portion of the estate. So somehow I'm suggesting to you, if you have a South African resident estate and you have foreign assets that is included in the estate duty calculation, you can distribute that foreign assets to the non-resident, but you must pay the estate duty, the proportional costs, your fees as executor, and the proportional cost from the foreign assets. So that part must be remitted. I also respectfully submit that this clause is outdated, because remember, it reads may be affected to non-residents. The exchange control rulings have now made it possible to distribute to residents as well, okay? So they can keep abroad. So first of all, I think that that circular is inadequate. So just to remind you what SARS said, there it is again. They are precluding resident trusts from vesting amounts in resident individuals, not vesting in individuals, but only as vesting to trusts is prohibited, or they're trying to stop that. So now I have finished off. We have 5 minutes. I intended to have some more question and answer times, but as you can see, I get carried away. I'm very passionate about the topic. So for Danny and Stan, thank you for the opportunity. I see no questions in the question and answer side. I don't know if you want to open up, people can speak. I don't mind. I will try and answer best I can.
Yeah, I don't mind letting.
Sorry, carry on, Danny.
Yes, I see someone someone has asked something in the question section. Jacques. Well, that was an hour ago. Sorry, so I must have missed. But go back. If anyone wants to talk, they could put up a hand. I can allow them access.
What was the question from Jacques? Did I not answer some of Jacques' questions?
No, do non-residents living in Oz or New Zealand pay tax on the living annuity? Sorry, or if they would claim tax credit from the tax paid here. I can't remember if you.
Yeah, no, I'll quickly answer that. That's a tax question.
Yeah.
If they're in New Zealand, the first 4 years of their tax residence in New Zealand, they don't pay tax anywhere in the world. They can claim the exemption. Just remember, the only problem is that the treaty with the UK says that if you do not pay tax in the other country, then you can't claim the exemption in South Africa. So for people in New Zealand, no obligation to pay tax in New Zealand, but people paying living in the UK, they can't claim the remittance basis, i.e. not paying tax in the UK, and claim the pay-as-you-earn exemption.
Yeah,
I'm not aware that those countries will pass a credit. They're very reluctant because remember, it's absolute taxing rights to South Africa. So I know, for example, that America does allow us tax credits on the South African living annuities.
And then I got another. I think Eunice might want to ask a question. Given you permission, if you need to speak, Eunice. And then while we did you want to ask something, Eunice? We're not hearing you if you are asking anything.
Eunice, perhaps your sound is off.
He's not muted. He's not muted. I can see a bit of, but I'm not hearing him. While we wait, with the one point on the foreign gambling, I've seen once in the terms and conditions of all these advertising on the radio and the news that actually you're not gambling on in the actual lotteries and stuff overseas. You're gambling on the outcomes. So you're betting what the outcome is, not as in playing, and it's generally licensed through a local gambling board, from what I've seen.
So it's worth taking a chance. Is that what you're saying?
No. So it's like they tweak it a little in the advertising. Like you think you're playing for the Euro lotteries, and you're going to win if you guess the numbers, but you're not. You're going to just guess whatever is in the local pot, gambling on it.
Oh, that's interesting. So they keep a South African fund and a foreign fund, so the money never leaves South Africa. That's an interesting.
No. Yeah. But it isn't actually. So it's not like you're not actually in the foreign lottery. You just
lottery, yeah. So they mirror or replicate. So I know the Lotto Star or whatever, to use brand names. If you look, they are registered in the Gambling Act. So when I say to clients, I don't know the legal rule, but you can look at their webpage. They are regularized in South Africa. So I'm sure that the Banking Act wouldn't allow
so that you aren't playing. You're playing in their prize pool, but not in the foreign pool.
Yeah. So you probably won't get the 30 million euros. You may just get 30 million rand.
Yeah, something like that.
Can you hear me?
Yes,
you're very soft, Eunice.
Can you hear me now?
Yes, better.
Yeah, thank you. Just to confirm what I think I heard earlier on, testamentary trust in South Africa, non-resident beneficiary, never a taxpayer in South Africa. He was non-resident, but he's a beneficiary of a South African resident testamentary trust. The trustees have distributed income to him. The TCS is that to be on the trust?
Trust. He has no tax now. If
he does,
provided it's not rental, provided it's not rental income, he has no obligation to register in South Africa.
So the TCS is on the trust.
Correct.
Trustees apply for a TCS.
Let's take that a little bit further. If they vested interest in him, then SARS will not issue the TCS unless there's a 15% withholding tax on the interest paid or vested to him. We are seeing SARS is not monitoring that correctly. I've seen TCSs where I've told the people when I must do it because I have a little agency transferring cash for people. Then I say to them, there's a TCS, but I'm putting it on record to you that you're not compliant because you are vesting interest and you should have withheld 15% tax.
Okay, thank you. Thanks very much.
Okay, so
I just want to finish, Eunice. To get that money out of the country, then we need a copy of that person's passport or some ID to show that he was not born in South Africa. And I always then get a sworn affidavit, or from the UK, it's an Officer of the Peace, I think they call it, declaration, to say that he's never lived in South Africa, is not tax resident. And I do ask him, just for safety, not many authorized dealers ask for it, but I ask that person to get me a tax residency certificate in the country where they reside. Belts and braces. I just don't want to delay money and delay transfers.
Thanks very much.
So, Hugo, thank you very much. Your timing is impeccable. Your information that you divulged is very important and very current and topical. And so thank you for the last 3 hours. It's very informative to me, I'm sure to everyone else. Thank you, everybody, for attending. Watch the space. We've got more seminars coming up throughout the year, and we'll keep you informed. And we're closing off today's seminar. We'll be sending out the certificates in a day or so. And if you need any questions or anything answered privately, send them to Danny and he'll forward them on to Hugo, which I'm sure will assist us. I'll leave you with just one thought I saw today. The difference between tax evasion and tax avoidance is the thickness of the prison walls. And so, really good night. I hope everybody's got a blanket to keep warm, and spare a thought for those people out there who haven't, and good night. Thank you very much.
Thanks, Danny. Thanks, Stan. Thanks.
Thank you, Hugo. Cheers, Stan. Cheers, everyone.
Cheers, everyone.